Hi guys, it's Kathy. I hope you're doing well. I would have got on sooner, but I fell asleep, which is why my hair is so wet. Not even you guys. Not even for you while I use a hair blow dryer when it's 70-some degrees out. Makes the point of the shower worthless. So I was almost an hour late for work getting this verdict. I just refused to leave the house until I had it and saved it and put it nice and safe. So I know it's not more than, okay, it's a bit long. It's fine. It will be fine. It's a bit long, but it's nowhere near 8 o'clock, so I won't touch Bill's stream. See, that's called, I don't know, responsibility. No, it's not the right word. But Marty, I'm not going to tell you the outcome. But remember, we're in a court. So the judge's job is to ignore all the facts that are not really relevant and only listen to the facts that are very relevant. And this judge is great at his job. And all the things that we are hearing during this trial, he's not hearing. I mean, he hears it and then gets rid of it. And you'll see that at the end, he takes the law and he applies the law. And everything else is just fluff for us to talk about in chat. So here we go.
Those little collectible,
Yes.
whatever they are, Warhammers, figurines, I don't know what they are, but you agree that that's been a hobby of his for some time?
Yes.
You agree his trading cards has been a hobby of his for some time?
And now he's saying it's a business.
Okay, well, but yes, but you agree it's for years.
Yes.
Have you ever told him you had an interest in the figurines or the cards?
No.
You ever asked him, hey, teach me about it, I'd like to learn about it, or I'd like to do all this with you?
I mean, he does tell me about them sometimes, but I don't ask to learn more.
And Cody, he's a good dad. He sees the kids every weekend, not just every other weekend as in the parenting plan. Isn't that right?
Yeah, it's half the time. So it's not the full weekend. It's one night every week. It adds up to be the same.
Okay, but you agree that you and him have agreed to deviate because the children want to see him more
Often. Yeah.
And so I was maybe reading between the lines in your testimony, but is it a sour subject for you that you didn't know about this cardboard, whatever it's called, cardboard, whatever he calls it, business until just trial? Is that right?
I wouldn't call it sour. It's just new information.
So you learned about it for the first time in trial?
Yes.
You didn't know about it in the report we sent last week?
No.
You didn't review the report in the 3.7 hours you were with your lawyer on the phone last week?
I would object to any question that would.
All right, I'll withdraw the question. And so in your mind, he should have told you, I guess, sooner about the new business, right?
Well, it wasn't supposed to be spent on.
Yeah, I know you lost audio. I know. For no reason. So I would have started earlier. I'm trying to set up a different software, a different streaming software, so this stuff doesn't keep happening to me. And I couldn't get it to work right. So I decided just to do this stream with StreamYard. And again, you guys lost audio. So I'm going to back it up 10 seconds. And turn that off. Turn it back on. Oops, wrong button. OBS is the most popular free software.
that. And now
Paid off your debts.
he used that debt from buying $60,000 to $70,000, which is a huge portion of the 117-ish he got for his bonus that we were asking to hold safe.
Okay, so do you not think you yourself should have any consequences or criticism for withholding $17,000 in cash withdrawals into an account that we didn't know about till trial?
Y'all have known about it.
We've known about you squirreling away
Judge,
$17,000?
I would
Yes.
object that my client can't speculate what Mr. McCormick nor Mr. Satterwhite would know about.
I think his first question was appropriate. It kind of divulged into an argument after that. So let's just move on.
All right. And my understanding is you're evaluating equipment of some sort at $500,000 from tax returns from 2 or 3 years ago. Is that right? 4 or 5?
I'm sure it has depreciated some, but
Sure, but you don't have an exact
I'm
figure.
closer to that number than the 200 that he's saying.
All right, so you agree, you don't have a number.
Right.
You've never had anyone come in and do like an evaluation or an appraisal.
No.
You believe that he has, I think, dissipated marital assets was the word, right?
Yes.
So you don't think you've dissipated marital assets with $28,000 in withdrawals?
No, because that money's still sitting there. It's in savings.
Well, we never got
It's
that-
safe.
Well, so I'm not good at math at all. I guess that's why I became a lawyer. But if you withdrew $28,000, you only have $17,000 in the account. Where's the rest of the money?
I
Judge
get,
asked and answered. She talked about her donations and paying her dad Monday.
Okay, so you don't think paying your dad all donations of $11,000 is
and then
dissipating?
sometimes in the summer, there's all kinds of things, but all throughout the year, but in the summer, the kids go to swimming lessons and that's all out of pocket, or it's all cash. That's all she takes.
You don't.
And they go for a week and then they go when she can fill in between after that throughout the rest of the summer.
So you pay that out of that money yourself?
Yes.
Cash withdrawals?
Yes.
All right. You don't think changing attorneys from $250 an hour to $400 an hour in January and running up $36,000 since January alone in attorney's fees is dissipating marital assets?
No, not compared to having the company come in and get a report that didn't really tell us much. And
Oh, you don't think that? Can you point to any document where you have ever voiced opposition to an expert?
it's the one that he said he thinks the value is higher.
Question though, can you point to any document?
And that was 35 plus
Okay.
thousand.
Okay. Can you point to any document where you have complained of an expert in this case?
I complained in that email that I just read that it was wrong, that the amount was wrong that was given to him.
All right, that's all I have. Thank you.
Can you redirect?
No, Judge.
Any other evidence?
My fees are in evidence already. I believe they're D10.
All right, let's do that. Can we just have you both state on the record your claim for attorney's fees, and then we'll stop and take a lunch break?
Absolutely, Judge. I'll acquiesce to the plaintiff, or I'm happy to go first.
You can go first. It's fine.
Thank you. Judge, my fees through Saturday, I believe it was Saturday, May 10th, whatever day that was, are in evidence as D10. The court will see that those billing entries are very specific to the point of copying and pasting emails from opposing counsel that required more time to respond or that would generate other work such as filing pleadings, et cetera. So they are rather thick. The court does not have before it any invoices beyond May 10th. We've been in trial all week. I will state in my place that I do bill $400 per hour. Family or domestic relations is the only area of practice in which I practice. I am appointed throughout Northeast Georgia as in various circuits in Superior Court and Juvenile Court to serve as guardian ad litem, investigating and advocating for the best interests of children, including this circuit in this county. I have served on the appointed list for the Hall County Juvenile Court for a number of years prior to terminating that.
Blah, blah, blah. Okay, if you just got here and you haven't seen any of this case so far, this woman went right here. They want a divorce. They want to divorce. They want to end their marriage. She requires lifetime alimony of, I think it was $6,000 or $7,000 a month, even if she remarries. And she wants the house and a lot of money. He has assets like Magic the Gathering cards. She wants all of that money from those. She wants him to pay for her college because she wants to go to college now. And the reason why she wants everything is because her mother had Huntington's disease. Her grandmother, they both died of Huntington's disease. And years ago, she had the genetic marker in her, she took blood tests and found the genetic marker in her blood test. That doesn't mean, that she's going to die of Huntington's disease, but that's what she has. So she wants him to pay for her for the rest of her life. A lot, not a little, because the $6,000 or $700 in alimony is on top of the, I don't even know what it is, $2,000 to $4,000 in child support. And then there's another fee we'll get to later that she wants. But she wants pretty much everything. She wants not only for him to pay for her for the rest of her life, even if she gets remarried, but a lot. She wants him to pay a lot.
Tenure. I am a registered mediator and have done that for a number of years. I'm licensed as of, I believe, June of 2017 and have been practicing ever since. I'm the only attorney in my firm in which I've operated exclusively since 2018 in White County, practicing in the surrounding areas. My hourly rate of $400 is commensurate with my experience and market rates of attorneys with similar experience, experience not just being quantified with a number of years in practice nor age, but rather true experience. The case law in Georgia does provide that the court can take judicial notice of market rates as to attorneys in the area with similar experience. Also of note, the court can, I would request the court be reminded when we were in court.
20 years.
I can't remember the date, the first.
I'm going to lose my damn mind. All right. It's not the cats. It's StreamYard. It's not the cats. Though I could just, let's just blame it on the cats anyway.
That was taken down by Yona Court Reporting, opined as to Mr. McCormick's hourly rate of $250 and my hourly rate of $400 being reasonable for both. So and that's already been addressed previously, the court will see in D10 that there is a number of entries that are of a lighter shade of ink, which indicates from my system that those are no charges. The court will see that my assistant, her hourly rate often is reduced extensively, at times over $100 per entry, or often no charged. And that's not required, but that's as a professional courtesy to my client and as a good steward of funds in my practice. And so the court's going to be able to see in that those billing entries that I've not billed for every little thing that I could have if it's reasonable.
I'm not trying to interrupt. I mean, I think she's just trying to state her play. I think she's moving into closing argument.
Georgia.
Well, I'm happy to, just assuming that there's an issue with reasonableness and my hourly rate, so I'm happy to reapproach my proffer. But so I guess I'll request direction from the court as to additional information as far as my fees and what I'm asking for, or are we doing arguments on that? And I'm happy to go either way.
All right. One thing I'm gonna ask you after lunch is to give me what you think your fees are as of right now, like what else is outstanding?
Absolutely.
Because I think I have somewhere up here, I think I have
64.
Plaintiff 64 that has totals, I believe, through May 7th for the defendant, and I'm not sure how far Mr. McCormick, how much more Mr. McCormick has, but I'd expect if y'all could just supplement, tell me what is owed in addition to what's on P64. Does that make sense?
It does, Judge. I'm happy to do so.
Mr. McCormick, you have any questions for Ms. Kimbrell?
Judge, just a couple. I will just reserve, since her invoices are into the record, just arguing as to the unnecessary charges and unreasonableness of the charges too. But I do want to ask a couple of questions. I don't need her under oath. Just a couple of questions.
Go ahead.
All right. So how long have you been charging $400 an hour?
I would say I went up on my rates this past year, so maybe close to 12 months. I'd have to go back and pull exact data.
All right. And so you heard your client testify earlier that she spent a lot of time on the phone because you were new. Does that mean new
Not
attorney or
new that
what was your
way.
understanding of that?
So,
Okay, so
I would say that was a mischaracterization of the testimony and evidence. But my response to that would be my billing records as to when I spoke to my client and how long are indicated in my records with a date and time stamp. I entered the case on January 3rd. And so if there's any question about specific timeframes, but I did not take her testimony to mean that I am new to the practice of law, nor new to the case and learning. In fact, you'll see in D10 that there are many entries, or there are some entries
More than that.
where there are phone calls placed between myself and my predecessor, Ms. Margaret Christie, that are no charge, because I am cognizant of the fact that the parties in marital estate, my client, should not endure additional time for me to ask questions that Ms. Christie would otherwise know. So those are no charge. I hope that answers it.
all right. So before you, in the past 12 months, went to $400 an hour, what was your previous hourly rate?
Oh, goodness. I wish I would have known I was going to have to pull back time. 350, maybe 300.
How long were you at 300, 350 an hour?
Let's see. I've been practicing almost 8 years. I'm an officer of the court, so I want to be honest. I can't give you an exact time. Heck, I can't even remember my first hourly rate when I was an associate at Coleman Chambers and Rogers here in Gainesville. It was I believe in the $250 range when I first started practicing, given that I had been a paralegal and had office management and pleading, drafting experience beginning in 2007. Then went to the DA's office, the juvenile court here in this circuit, and interned for law firms in Atlanta. So I was a little bit, I think I started around 250 in 2017 when I was an associate attorney.
Do you ever make exceptions to your $400 rate since you've been charging $400 in the past 12 months?
Do I ever make exceptions? Well, certainly you'll see in D10 where I've reduced my rate as a professional courtesy, but I'm not required pursuant to a contract to do so. And I'm not willing to discuss my provisions with other clients. But on this case, I've certainly done that as a courtesy to the circumstances of my client.
Do you do appellate work?
Do I do appellate work? Yes.
So you file appeals?
No, I'm actually working on one now.
Oh,
In fact, I have one of yours that I saw come out last year. And so I do a lot of appellate research, but I do have an appellate case right now.
Have you ever filed an appeal at the Court of Appeals at the Supreme Court of Georgia?
No, sir, I have not.
Okay, that's all I have. Thank you.
All right, thank you. All right, Mr. McCormick, anything you want to say about?
Judge, yes, I'd like to state my place. So I'm a graduate of the University of Georgia School of Law, graduate since 2009. I hold a bachelor's from the University of Georgia. I hold a master's degree from the University of Georgia. I triple dog, so to speak.
I bet she charges a bit more now, though, I know.
I worked in Washington, D.C. for a U.S. Senator, Johnny Isaacson, God rest his soul. I'm fluent in Spanish, doesn't really apply to this case. I'm a Rotarian scholar, spent just under a year in Mexico, bilingual, started my own firm in 2011. I'm out of Cumming, Georgia. I've been a sole practitioner since 2011, just a couple of years out of law school. I hold a satellite office in Sandy Springs, Georgia. My hourly rate normally is $3.25 an hour. I've charged my client $2.50 an hour under the circumstances. That was actually in the
Thanks, GM.
retainer from the
Did I say
get-go.
that right?
I think my fee is necessary, customary, and reasonable. I do engage in routine appellate practice. I'm not bragging, but sitting here yesterday, actually, I got notice, the Court of Appeals reversed Superior Court of Douglas County on a civil case that I filed. It was a reversal. Last year, 2024, Court of Appeals reversed in part on a child support issue, Superior Court of Cherokee County, 2023.
Like you do in jail.
Court of Appeals remanded court from Cherokee County, all domestic cases. I do domestic cases. I'm actually getting out of domestic work, but I've been doing it for 15 years. I'm a sole practitioner. I do criminal defense, domestic, civil personal injury. Again, I think my fees are reasonable, customary. And again, I'm not bragging, but bottom line is I think staying in my place, $3.25 is absolutely reasonable and necessary. So, sorry, $2.50 now is reasonable and necessary. So, all right, thank you.
All right,
I don't have any questions. He's very qualified, Judge.
all right. 2:30, not enough time for y'all to get lunch, come back at 2:30 and do closings?
Can we have till 2:45?
2:45?
Yes,
That
Judge.
sounds good to me. 2:45.
Thank you.
Just want to get done today. I know y'all do
Yes.
too. All right, see you back at 2:45.
Thank you.
Can you gonna lock this up so they can leave their stuff, or
Or you
or
stay?
somebody gonna stay? Do y'all want to just sit here and eat? Or-
All right,
What's
we don't
that?
need to hear this.
$1 a month in child support. Well, he's willing, he'll give whatever he's always ordered to pay, but that's what he's willing. That's what he's imputed his income even more to be more reasonable. $10,000, Judge, just to try to placate and to show, maybe what again, he's not a CPA, he's not an accountant, but hey, maybe some of these things that have been written off, maybe it's not, fair. So $10,000. That matches their worksheet. They didn't come in here with a worksheet for $50,000. They came in here with 2 child support worksheets, $39,000, $40,000. He's agreed to that. So they presented nothing contrary to that. So even if if she gets up here and tries to argue for the first time, he should get more than that. Yep, can't do it. They didn't present it in evidence. So
I don't know. I don't know why it's doing this. Because it hates me. This is not a 30-minute video. This is a little bit longer than a 30. Just the judge's decision alone is 30 minutes long, I think, because that's why I was late for work. I stayed here until the judge was finished talking to get this verdict, and I was late for work. This has to stop doing this now. It just has to just work.
The kids, 90%. The court's inclined to make them pay 100%. It is what it is. But I mean, I don't really see what the need is. You know, once she's done with school, she'll have a degree, and you know, she hasn't even started looking for work. She's just sat on this for 2 years, knowing this day was coming. And so, I mean, how is that fair? It'd be one thing if she was looking for work and just couldn't find it. Zero effort. He's not a millionaire. He, you know, wasting, dissipating the estate. I just don't see it. I mean, they throw all these just general dispersions that, oh, he's got a girlfriend. They didn't plead adultery, which, you know, I get it. They didn't make a big deal about him having a girlfriend. You didn't hear one complaint from her. You know, she's not a good person or anything like that. She doesn't have any problem with every weekend, every Friday, her children going over there. And so talk about dissipation of marital assets. I mean, I'm not beating the dead horse here, but you know, those charts that we put together, I mean, that speaks volumes. I mean, attorney's fees. I understand we're all here to make money. That's why we went to law school. But my gosh, I mean, you know, some exceptions should be made if you're taking over a case that's been sitting for 1.5 years and, you know, want to charge double. I mean, I'm about to get into that. I mean, Miss Kimbrell has charged more than me. She's been in this case since January. I've been in the case since September 2023. So again, I'm not trying to say, you know, she's not worth it, but I mean, this is
One of the things that dad or husband or whatever you want to call him is asking for is that the judge stop her from using any of the credit cards at all.
it's just if her client had some skin in the game, I highly doubt $400 rates, over $40,000 estimated in attorney's fees since January would have been incurred. And so, you know, I just think should be considered as former support, how much she chose to dissipate the marital estate and attorney's fees. The court's not inclined to award, you know, my client reimbursement. I get it. You know, my client understands it. He gets it. But my client should absolutely, out of a fairness argument, have that in consideration, that she chose to not only reject offer after offer after offer, which, you know, if necessary and you want to see what the offers were, it'll probably, you know, shock the conscience. But you know what? That ship has sailed. She's decided to blow up attorney's fees and practically waste the marital estate with over $100,000 in total attorney's fees and expenses of litigation when she could have had that money for other purposes. So I think that cannot go without notice. As well, there's nothing that was focused on after 2023 that, from what I could tell in the cross-examination, which was more akin to a deposition in my view, to show to this court what the valuation of these businesses are. It's simply pure and utter speculation, and that's just not what the law allows for evaluations of interest. And it's you know, they didn't ask for a continuance of trial. They did, you know, I know they filed their motion to compel, but the bottom line is we're here in trial, and that they had every opportunity to pull in here whoever they want to pull in here. Didn't happen. I think, you know, he's absolutely not committed perjury. He's testified to whatever he could based on the voluminous documents that was presented based to experts. And he's testified truthfully what he understands the valuation or lack thereof is to his multiple business interests. And I think it cannot be ignored that he presented in his testimony. He even did it yesterday before this morning. I met with him and did this worksheet when he was testifying. He utterly admitted, yeah, I don't think that the valuation that the experts did was high enough. This is what I believe. I mean, absolutely transparent. Again, the wife had every opportunity to refute through evidence, not through opinion, not through disparagement, but through evidence of what the valuations are, and she's just failed to do so. His income is $29,000-$30,000 a year. He's willing to impute it at a burden to him to an additional $10,000. That's absolutely fair. They've presented no evidence to show that he can pay off the mortgage. When you get divorced, it's a complete.
Hi, Taze.
But it's unfortunate, but that's what happens when you get divorced. Now, we brought the real estate agent in here, and we're not going to ask the court to assign her individually, but we are going to ask the court to allow him to pick the real estate agent because there's no evidence. Well, actually, there is evidence presented that she's just not going to cooperate. And so, we need a court order that says she is ordered to cooperate with the real estate agent. And so, my client's willing. He's showed his willingness and ability to engage a real estate agent. And we want that part of the order is that he gets to select the real estate agent. It needs to be listed in a soon practicable time. If the court is inclined to see if family members of her can help her refinance it, he doesn't care, but he's got to separate that debt. There's no legal authority I'm aware of that this court is allowed to encumber him with additional debt in order to, transfer an asset free and clear, particularly when he's already giving her practically the entirety of the marital estate absent the business. The one thing he wants, Judge, is the non-fungible, obviously his car, it's debt-ridden, is he wants his hobbies, equipment, mannequins, whatever they are, statuary, figurines, and he wants his unfungible business interests that he, through his own sweat, his own hard efforts, recently started to acquire. There's just, in my view, there's no way to award her any of that other than maybe liquidate the cards for sale, et cetera. So I'm kind of beating a dead horse here. But then my next point, Judge, is she's transitioned into the next issue, the cause of the demise of the marriage. She's not the victim, as she wants, vaguely wants this court and everybody to believe that he is. She has vaguely, without amendment, pled cruel treatment, albeit the reverse attorney was never amended. There was nothing in the answering counterclaim. I read it very carefully that identifies if it was bodily or mental.
Yo, slow down. Listen, never call your ex for any reason. Never. Don't do it. It's a trap.
I was waiting on it. There was no testimony that I could recall, particularly on direct today, that even if there was infliction, willful, by the way, willful in my view means unprovoked. So I was waiting on it. There was no cross-examination of my client as to his testimony yesterday, as to his self-defense. Zero cross-examination on him on that issue. So I take that as a fact admitted. The wife, she didn't testify about it either when she was on direct. So again, I take that as, an admission against interest in essence that they're just not refuting his claims of self-defense. So they're asking for your honor to put in a public record that this loving husband, loving father, is a cruel man who has just treated abominably his spouse, and so that he should have forever for the world to see cruel treatment under 19.5.310, despite the lack of specificity in the answering counterclaim, when all he wants is the marriage to be irretrievably broken, which is customary under 19.5.3.13, which, he wants not only for him, but when his children grow up, if God forbid they have to look at a divorce final order, they see that, hey, marriage just didn't work out. It wasn't because my father was some monster. So I think that's important. And as to this cruel treatment, even if you think the wife was credible, which she was, again, all over the place, very vague, contradictory in my view, they didn't produce one piece of video evidence, even though apparently they said they had some video of him smacking a phone out of her hand. Didn't play it. I don't know why they didn't play it, but I think they do. I know why. It's not as bad as it may have seemed. But also, no photo. She testified that she had cuts and bruises all over her. Not one. And she even said she sent it to her, but not one photo came into evidence. She talked about a 2021 phone incident. 2021. This is 2025. The parties separated in 2023. She even testified in interrogatory responses that they had sex and kissed just days before he was arrested on July 23rd. So obviously that pattern of cruel treatment didn't exist.
That was another thing though. It wasn't enjoyable, so it traumatized her. She needs a therapist.
Within days. Otherwise, I couldn't imagine why she would have had been intimate with her husband. And then her only other, instance of cruel treatment was 9 years ago, because her child is 9, Oliver, as I understand it, when he was 2 months old, as she testified today. So, under my jury charge number 14, the law, in my view, it's pretty clear, and that the law is ordinarily a single act of personal violence is not considered cruel treatment. But the law does say one act may be sufficient if it's severe and atrocious enough. I don't think that under the facts and circumstances of what was presented in uncontroverted testimony of Mr. Satterwhite, that was so severe and atrocious for one instance put on, public record for the rest of his life, that he's a cruel monster and animal, particularly since, conduct's not really at issue here. He's willing to give her practically the entirety of the marital estate. So I'm long-winded here. I'm moving to conclusion, but the next point is child support. And I succinctly summarize that in charge 51, and that summarizes 19.6.15 F4D. And I think our worksheet is fully compliant with the financial circumstances of the parties and the needs of the children, which this court is, inclined to do. It's not child support for the children. It's not to, punish him or offset her in some other way. She's testified that the children have never done without, and I don't think there's any evidence that they will ever do without. This is a very loving father. He pays everything. He's willing to pay practically everything for these children. I think the evidence is uncontroverted that she is willfully and voluntarily underemployed. Again, she's just, she's content just to ride on his coattails, but that's just not that's just not fair. It's not fair, and it's not the basis under the law to award her under employment with this court accepting her child support worksheet that, which I put in the evidence, and there wasn't even I could even remember a question about it really from during direct. Now I covered a lot of this in cross-examination, but 700, that's just outrageous. The court's inclined to accept her own previous worksheet from February was $2,000. So
one thing on your child support worksheet, it looks like the only deviation was for health insurance, $828. Is that right?
Yes, Judge.
Okay.
I was moving into that right now, and he actually testified today. I guess he actually pays more than that, double than that.
I think that's bi-weekly.
But it doesn't matter at this point. He submitted it. He's willing to pay what he put on there. So, and Judge, in network is very important. There's no reason she can't find a counselor. There was no testimony what these kids need counseling for. for the life, I mean, assuming he was such a monster 2 years ago, they got a 4-year-old. That child would have been 2 years old at the time. What does a 4-year-old have in their memory that can have been so atrocious that they need perpetual counseling? I mean, it's just outrageous. Now, look, she's a loving mother. My client, I think, concedes that, obviously. He agreed for her to have primary custody and final decision-making. If she truly thinks these children need counseling, that's why he pays all this insurance for. What's the problem with finding an in-network provider? There's no testimony she even looked. So, it is what it is. But I mean, he absolutely would like this court to put in the order that she has to pay 100% if it's not in network, or at least pay half of it. So she has some skin.
We know a bit. We know the order is he gets every other weekend. I don't know about holidays. I don't know about summer. I don't know any of that. He gets every other weekend, but they agreed to change that, outside of the order, where he gets 1 day every week, 1 day of the weekend every week. So it's the same. He gets 4 days a month.
In the game here. And so obviously my client is frustrated with all the attorney's fees he had to pay. We did follow the procedure. We've followed, we amended our complaint, 1962. There's nothing in the law that requires him to ask for alimony. She asked for alimony. All 1962A requires is when alimony is sought in a divorce, and there is the issue of what's considered for financial circumstances. He has a basis to ask for it. Now, does he want her to write a check? No. Does he need an accounting of what's left over, at least from this $20,000 that was paid just last week? Absolutely. If we need to have a separate hearing on 9/15/14, we don't want to do it. Frankly, Judge, he just wants you to rule. He wants it to be, fair and equitable enough that he can move on with his life. But if it's so burdensome to him, he's going to have to, he's intending to ask for attorney's fees under 9/15/14 because he shouldn't have had to spend all this money. He would rather just, get the order, pay what he's ordered to pay, move on with his life. But there needs to be some type of accounting and accountability for just running up fees. We didn't even litigate. We never had a temporary hearing. We showed up for a temporary hearing, but we never even litigated in a contested hearing, custody or anything. There's just no reason these fees should be where they are. None. I'm not going to waste any more time going through all of these invoices. They're in the evidence, but to charge $40 just to review an email, and just a 2-sentence email, charge $40 just routinely. I mean, that adds up. 3.7 phone calls. $2,000 for a phone call in 1 day. I mean, my goodness, it's outrageous, frankly. So that needs to be taken into consideration in our view. Now, you asked for what the total fees are. We have the spreadsheet at 64. While we were sitting here earlier, I calculated, in my view, that before trial today, based on the invoices I had, Ms. Kimball charged since January 1st, $35,597.98. 4 hours, $400 an hour. We were here for 8 hours on Monday. We took a very short lunch break, so I don't think I charged my client the full day. That's $3,200. Yesterday, we were here for 7 hours, but we did take an hour lunch break. So I'm assuming she's charging 6 hours, not for lunch. And I'm assuming there's charging not for drive time, because I didn't charge for drive time. That would be $2,400 for 6 hours yesterday. We've now been here 6.5 hours. I put 6 hours here. That's another $2,400. Well, we took a lunch break, so that would be 5 hours. So $2,100. So that's a total for trial alone, $7,600. It's just outrageous. She paid her previous attorney on the credit card. My client's paid $18,447.37. So now my fees before trial were $36,964.03. That's for me being on the case from day one. At 8 hours, 250, it's 2,000. $5,000 to my previous balance. That's $41,964.03. You also heard, Judge, I met with my client this morning. I didn't even charge him. We were doing this stuff early this morning. I volunteered to write the final order. I won't even charge my client for writing the final order. So again, I think the attorney's fees, we're not asking for her to write a check to reimburse them. We're simply just asking. When I say she, the wife, he absolutely wants an accounting of what's left of the $20,000. But nonetheless, that should be considered for the basis of alimony for past amount she's been paid and for equitable distribution. My final points here, Judge, is, so what? He traveled. So what? He moved on with his life. Yeah, he works hard. He's been paying everything for her. Good for him. He's got somebody who likes him. The balance sheet, again, I think the balance sheet is very fair, very transparent. I think Your Honor needs to be aware that she squirreled away $17,000. That's a form of alimony in and of itself, in my view. She testified she's got, I think, $600 sitting in cash too. So she's not going to be left desolate here. And my final point, the uncontroverted extortion. I was waiting for there to be some explanation as to how she said, oh yeah, well, I put it in the evidence without objection. Our family wizard, the first 4 pages, all
I don't know what's happening. Yes, I know. I don't know what's happening to StreamYard today, and I don't know how to fix it because it's not me. It's this. Okay. Just gonna truck on, guys. It's fine. It's all fine. It's the universe saying, universe telling me that I don't pause enough to talk. What's just going on? StreamYard is saying I don't pause my videos enough to talk.
I'll agree to diversion, dismissal, $100,000. If you don't want to pony up $100,000, $50,000, and I'll work out I'll agree to a plea deal so you can stay out of jail. Thank you.
That's illegal, guys.
Judge, may I approach?
Yes, ma'am.
Or I'll hand it to Leah. What the bailiff is handing Your Honor and I've given to opposing counsel is a summation.
Sorry, I said in my opening statement, I am objecting to this consideration. I understand Your Honor asked for notes, but my understanding that would have been presented during trial, so I could have opportunity to cross-examine on the topic. So, but nonetheless, I've made my point. So,
Judge, this is
All right.
not evidence. This is a summation as the court requested yesterday.
All right, overruled the objection. Anything that's in here that wasn't presented in the evidence, I'm going to ignore, Mr. McCormick. So,
okay, I understand.
Thank you, Judge. It was prepared after evidence.
The dad did get arrested in 2021. There was an incident in the car. He says she started stabbing him with her cell phone. She said he hit her, whatever, when she was trying to get out of the car while it was moving or whatever. So he was arrested back then. Then fast forward 2 years later is when they separated. And then 2 years later is today. So, wait, there was another, okay. This part is a little boring because they talk about, they go into fees and everything, but listen, just stick with it because the end is great.
All right. Judge, there's a few points in which the parties agree. The evidence did show that this is a 20-year marriage. In today's time of 2025, that's nothing to, that's not too common. We don't see 20.
And I know that her microphone is a little echoey. They try to fix it in a second. They sort of a little bit fix it. StreamYard is like me. StreamYard is like, I'm going to work for 3 minutes tops and then I need a break. 3 minutes and then it's break time. It's not my computer. It's not me. It's StreamYard. It's them.
That the party that they separated in July of 2023, they agree that they have 2 children. We have Oliver. He's a 9-year-old little boy who does go to Walk a Mountain. I believe he's finishing up the 3rd grade. And he enjoys going to Ninja Warrior in Brazelton. We have Amelia. She's 4. She'll be in pre-K this next year. The parties agree they have a marital residence. They agree it's on Skits Mountain Road. The parties agree, as offered in opening and accepted by me in opening, that Mr. Satterwhite will pay for 90% of extracurricular activities. They agree to that. They agree there should be some form of support paid. They agree this has been a difficult case and that there's been a lot of money spent. Beyond that, I'm not sure there's much else the parties agree to. Judge, starting with the grounds for divorce, Mr. McCormick, I guess we do have another agreement in that the defendant filed a counterclaim through her former counsel alleging 2 grounds under OCGA 19-5-3, the no-fault ground of subsection 13, irretrievably broken. I think the parties agree their marriage at this point is irretrievably broken under subsection 13 of 1953. In addition to irretrievably broken, Ms. Satterwhite pled and maintains the fault ground of cruel treatment. Cruel treatment is defined by statute in Georgia as the willful infliction of pain, bodily or mental, upon the complaining party, such as reasonably justifies apprehension of danger to life, limb, or health. Cruelty does not always leave bruises. Sometimes it's the steady erosion of someone's dignity, their confidence, their sense of reality, excuse me. And that, too, Your Honor, is abuse under the law. Opposing counsel in argument and during cross-examination referenced and then questioned my client about bruises, photographs, videos. Is that the standard, I would ask the court, that the Georgia legislature and General Assembly intended to be followed by the courts when determining if there's been domestic violence or if there's been cruel treatment? Do we have to get to the point where we can see the scars on the outside of the victim's body before we believe that person? That's what the plaintiff's side of this case would have this court believe. Plaintiff wants to move on. The defendant wants to survive. Judge, that's the difference in this case. There's been a line of questioning in this case where one could.
Fozzie, thank you so much. I appreciate it. Yay.
Summarize the following. She doesn't look sick, so she must be fine. She doesn't have any symptoms. I didn't notice anything, says counsel for plaintiff, as if that's the standard. Sickness is not always on the outside of our body. Often we are sick before we're even diagnosed, before we know it, and we have days left. She stayed at home with the kids, Judge. Her value must be zero, but it's not must be zero. In fact, when I asked Mr. Satterwhite about his wife's support of his businesses, when he created the first two businesses, said, you would agree your wife was at home raising children, tucking them in, bathing them, feeding them, comforting them. That has value, does it not? I said, well, what value does it have? Zero. Very affirmative in quantifying his wife's value as the mother and raiser of his children, that he wants this court, through his attorney's argument, he's a good dad, he's a loving dad. How could we possibly put in a document that he has cruelly treated the mother of those children?
Yo, Fozzie, you got some great ones in that one. Thank you.
While also arguing in the comfort of this courtroom through counsel, her value is zero, Judge. Could also say the position of the plaintiff's side in presentation of evidence. My wife's lawyer, my wife that has zero value, her lawyer, she's never filed an appeal, so therefore she must be inexperienced. She charges too much. Why, Judge? Because plaintiff and counsel say so. Every time defendant pushes back, whether it's through counsel, through pleadings, or through her own.
She never filed an appeal. This attorney who charges $400 an hour has never appealed a loss.
Words. Every time she stands her ground. Plaintiff's side of this case tells us to sit down, be quiet, stop making noise. Or as the plaintiff so freely testified that he said to the F down and shut the F up. As he continues to drive, as she's begging him to pull over, as they're leaving Nacoochee Tavern, as they're driving past Nora Mill, as she's begging him, please, she's tapping him, honey, please slow down. Please let me drive. She starts to open the door, hoping that that will awake her enraged husband to pull the vehicle over. He testified almost as if it was justifying what happened, which was shocking, frankly. Yeah, she opened the door. I swerved to the left to close the door. Judge, he testified they then drove to Duncan Bridge So as he swerved to the left, coming from Helen headed towards Duncan Bridge, swerving to the left in oncoming traffic in a congested pedestrian area. That would be the third time that day. The first time was when the guy said, "You can't park here, sir. We'll tow your car." He said, "I don't think so. You're not going to tow my car." Because that's the kind of attitude and pattern that Mr. Satterwhite possesses. And so he then did it again. Right. It's an open area. You can see cars coming. So he stomped on it, he said. He slung gravel. But that was okay. He then did it again as he swerved into the left lane to shut his wife's door to keep her in the moving vehicle because she wouldn't sit the F down or shut the F up. My client continues to try to seek help. She gets her phone. She's trying to call 911. He testified he knocked the phone out of her hand. He testifies as they got on Duncan Bridge. I think the testimony was, I guess she got service. She had his phone, and he knows she's on the phone because he says, "I'm trying to say something about, stop hitting me," hoping the 911 operator will call, or will hear, excuse me. Knocks that out of her hand. They continue to drive down Duncan Bridge Road through White County, headed towards home. His testimony was something But before we did that, he's driving. He says, "I thought out of the side of my eye, I thought I saw something. I thought she was trying to hit me." So what does he do? I may never forget this. He slaps his hands together as loud as it could be in this courtroom to show the court exactly what level of force and control he exerted from his hand to the back of his wife's head because he thought he saw something. But why do these kids need counseling, Judge? Why do they need counseling? What could a 2-year-old, now a 4-year-old, possibly need counseling for? By the plaintiff's actions in this case, he has provided this court evidence of his toying with the control that he has always exhibited, that he seems to enjoy, through discovery, a game of hide and seek, very apparent, through the pleadings filed in this case. Judge, I would argue this is not just a divorce. This is an extension of abuse by other means. What began in the home when Oliver was 2 weeks old in 2016, continued in the driveway in 2021, and finally in the car in 2023 when he open hand, not punched, he made sure to draw that distinction, open hand slapped my client in the back of the head because she just wouldn't sit the F down and shut the F up. It's continued into this courtroom. Your Honor, cruel treatment doesn't stop when the parties separated in this case at all, nor did it start in July. There's a pattern, a sufficient pattern to meet the grounds pled.
I need to get this straight. They're accusing him of cruel treatment of her. That's what they're saying right now, that he has given her cruel treatment.
Of cruel treatment as requested and pled by my client in her answer and counterclaim in this case. Opposing counsel argues in his closing, Why did Ms. Kimbrell not ask my client about self-defense? Silence, is that an admission, an acquiescence? No, Judge, because it's frankly not my job to ask his client those questions. He admitted on the stand by questioning from his own lawyer that he kept my client in the car and interfered with.
Yep, they are going through a criminal case, and he's fighting it because he's saying that she started hitting him first with her phone. She's saying he hit her in the back of the head.
2 911 calls and then
He
opened
admitted
and
hitting
slapped
her
her in the back of the head before leaving her on the side of the road. I don't need to ask those questions. Why didn't we produce video evidence?
She is. It costs him $300 a month for her therapist, which she wants him to continue paying after the divorce forever. Her therapist, $300 a month.
Judge, there was constant complaints about how long we've been here. As a reminder to the court, not that the court needs it, but the plaintiff's side of this case announced 2 days for their side. Today is the third day. It is 3:41, according to the clock on the wall in the courtroom. I opened my case in chief and concluded it today. I had one witness.
If it does it one more time, I'll restart, but I might lose the whole stream.
I didn't take an exaggerated amount of time. I didn't drag in every person I could find to add another number to the court's pile of numbers it already has to look at. Why didn't I show videos? Because I have the testimony that's the sworn truth, whole truth, nothing but the truth, so help him God, directly from the plaintiff himself. I didn't need to bolster his admission. Judge, my client is preparing for a terminal illness. She's raising children, and she's asking this court for a measure of security so she can focus on living and not just surviving. She doesn't have the luxury of planning for retirement. Her retirement plan is to live as long as she can and to do so with dignity. Opposing counsel wants to know or argues, why did the defendant's side of this case wait until the end of evidence to ask for what we've asked for? It's very clear, Judge, because the very thing that my client and I have been accused of, which is being misleading and filing baseless motions, because they've produced everything, Judge. There's emails in evidence. I believe it's D14. They're all in my billing entries. We've given you everything. You've known about this. If you bothered to read the report, you'd see this. But then the plaintiff testifies under oath when he's got documents before him. Oh yeah, I never gave you that. I never gave you Square. I never gave you PayPal, the Beyond September PayPal. Didn't give you eBay. Nope. Facebook Marketplace. Nope. Reverb. Nope. Didn't give you that. Distributions. Yeah, I can access them, but I got to do it at home. Okay. Did you bring them today? No, I forgot. What is that, Judge? That is a lack of credible evidence as to income and assets. Did we ever get profit and loss statements from these businesses? No. No. He's the only one who's responsible for preparing and producing those two. His tax preparer for his business.
She just did try to cry a little bit right there. She tried and it failed. So she just kept going.
And responding to discovery. We still don't have those. I would agree with opposing counsel that he's a very learned counselor of law. And certainly.
And we are all going to get sick and die. I mean, all of us are going to get sick and die. She has a possibility, 50% chance, I guess, of getting sick and dying this one way. But we're all going to get sick and die. You can't go into a divorce case and say in the future I'm going to get sick and die, so he needs to pay me because I'm not going to be alive for long.
He knew that his client had a duty, as did the plaintiff, to produce all forms of income. It is blatant. It is in the request. The requests are attached to the motion to compel that was filed, as are the good faith letters. We don't have credible evidence as to assets and income. I can't help but argue there's an intentional reason. There's something to hide. It's another smokescreen.
I do not want to. No.
So we waited until the end, Judge, because this has been like a movie I've never watched before. Watched a lot of trailers through reading Discovery. I've been told a lot of things about what to expect. But until we closed evidence, I really didn't know. There were things unfolding in the last 7 days that never knew. Things yesterday, never knew. So it was really difficult to prepare what we were asking for when we don't know what there is to ask for. And so that's the reason, Judge. Why did my client not amend her financial affidavit? She did. She complied with the court's order. It's very clear. It says update the income. It's in a court order. Let's talk about the cruel treatment and financial abuse. Mr. Satterwhite did not just manage money, he weaponized it throughout the marriage and currently. The reason that he needs this house out of his name was an interesting argument, I'll give it that, because he needs to add his name to his girlfriend's house. Why did he buy a brand new 2024 Toyota Sequoia Platinum, albeit not the highest edition you can get, Judge, just the second to the top tier? Because he needs to carry his children and his girlfriend's children around the 4 days per month that he has his children. So naturally, one
I think if you ask nurses right now that if you're determined that you're going to die at a certain point, like you have a better chance of dying at that certain point.
would go out and spend $90,000 during a contested divorce when there's a standing order in place. Of course he would start a business. Another business. Of course he would spend $60,000 to $70,000 from December until March on cardboard. He couldn't dare be bothered to consider keeping, as his attorney argued in closing, his wife on his hip. He needs to be separated from her. He's used financial records and lack thereof as leverage, and the various false budgets that he's filed, known as domestic relations financial affidavits, this year alone, none of which match each other. The $40,000 alleged expert, none of those figures match, nor do they match the tax returns, nor do they match, frankly, the budget or the summary that was provided today for the plaintiff.
She did make a good point there. While they were going through the divorce, he was supposed to not spend his bonus of $117,000. That was just his bonus. And he spent $70,000 of it to start a new business.
None of the figures match. Plaintiff has no qualms about spending freely on himself while telling his wife in this court there just isn't enough to go around. If the court recalls, when we looked through one of his various sworn financial affidavits he's filed just this year, we went through the rent section, and I noticed that one didn't match the other. Well, we had one.
They did the children in the custody hearing. This is the divorce hearing.
It had I think it was a $2,500 section. I said, okay, well, $1,300, that's the studio rent. Yeah, okay. We got the $1,600, that's the marital residence. Well,
they're going to try to fix it.
what is this one? Oh, well, that's what I should be paying to my girlfriend, but I'm not. Okay. Then we see lawn care, $200. Well, when we dug a little bit deeper, oh, well, that's actually the $200 that my wife pays from the money that I'm going to later, this is my argument to the court, later complain that she has been withdrawing money from the ATM. Well, she testified and he agreed. She's been paying her dad to care for the maintenance of their property, $200 a month from that money, but yet it's on his financial affidavit. from, and it's the plaintiff. That's a credibility issue, Judge. Plaintiff wants to reduce his wife's 2 decades of sacrifice to a dollar figure. He wants to pretend and even testify under oath that being a homemaker and a mother is just simply a gap in his wife's resume. Why? Because he's asked this court at various intervals through his proposed child support worksheets to impute her at $5,000 a month. Judge, the testimony was, my wife hasn't earned that since maybe 2010 to 2012, prior to us moving to Green Bay. So he acknowledges that she hasn't earned that in a long time. Ms. Satterwhite raised the children, she's managed the home, she's supported his career, and now after building a life together, he says she deserves nominal amounts because she's had her helping of the marital pie. And that the helping of the marital pie is in evidence marked as Defendant's Exhibit D-CC. That is the American Express card that my client has had access to in the 20 months that the parties have been separated. He doesn't want to take into consideration that the school tuition's charged on there, that all of the uncovered medicals are on there, that support for the children is on there, that things for the home was on there. And then my client was questioned about her hobby of purchasing secondhand clothes for her children. No, Judge, what that is someone who is conscientious of the sinking ship of financial rubble that her husband has created. She's trying to be mindful of the fact and not expand the debt that has been created by her husband that he now so freely says, Judge, I'll take that. No problem.
She's trying to be mindful of the debt and not spend money, guys. She's like a saint sitting there. I don't even know why we're in court. Saints should not be allowed in a courtroom.
Problem? Well, of course he'll take that. It's all his debt. My client had no hand in anything except for one charge on a Chase Marriott card for fees that he authorized, and the American Express that she's used for all of the things for the children, the household, and herself in 20 months. Mr. Satterwhite says that he's not Miss Satterwhite's piggy bank. But for years, she gave up her own earnings to invest in their family, but that's of no account to him. Why? Because he needs to move on with his life. This isn't about fairness to him, it's about his freedom to spend, freedom to hide, freedom to start over without accountability. He wants this court to bless that freedom at my client's expense. Counsel argues she chose to get a divorce instead of staying with my client. She was served with a divorce and made that decision to counterclaim for divorce because of her cruel treatment and her safety. And she decided to put her safety and her children's safety first and finally stand up for herself.
The secondhand clothes she bought was to donate to a charity.
So because of that, they seem to argue that she shouldn't get what she is equitably entitled to pursuant to Georgia law. Judge, alimony, the factors that the court looks at are 19.6.5. The court may grant permanent alimony either from the corpus of the estate or otherwise. The following shall be considered in determining the amount of alimony. Standard of living established during the marriage. Uncontroverted, they took multiple vacations throughout their marriage, 2-week trips to Hawaii, Aruba. I think that that's clear in both sides of this case that they like to travel a lot. She was a stay-at-home mom. There was no controversy there that was the plan and that she has been in that role since Oliver's birth. Counsel for plaintiff argues that my client has been unbothered in searching for a job and has just sat around for 2 years. the court should be reminded that my client has been employed as a preschool teacher since this past fall without a court order requiring her to do so or a demand from anyone else. That was of her own volition. And that speaks volumes about my client, because that's not often that a court sees a marital estate of this value and the requester of alimony voluntarily becoming employed despite all adversity. The dismissive attitude of the plaintiff that a preschool teacher is not enough tells me all I need to know about who was the homemaker and the raiser of children. You couldn't pay me to be a preschool teacher. That is a tough job, and my client does it day in and day out with a smile on her face.
He never said being a preschool teacher was not enough. That's just absolutely not what he said. But she only works like a couple hours a week. And she earns like what, $700 a month. But she's able to earn a regular paycheck. She just is.
Her face, but that's not enough, Judge. That's not enough for the plaintiff. Duration of marriage, 20 years, age, and the physical and emotional condition of the parties. The evidence is uncontroverted that she has the gene mutation for Huntington's. Why would we spend more money that's already being complained about to bring in another person to say what she already knows about her own health and her own future? That would be a waste of money, just as the Nicholson Group was a waste of money in this case, and a dissipation of assets that were unnecessary. So we didn't do that, Judge. But her circumstances are real. The court's to look at financial resources of each party. Plaintiff had no qualms about investing $60,000 to $70,000 of marital money into a new business venture that, by his own words, will increase in value after the cards get done resting. The court should take that into consideration in apportionment of equitable division, as well as alimony. I think my client seems only fair or otherwise equitable that she get a return on that investment that she didn't authorize. Um, 1965.
I don't know if she's not being treated by a doctor for this. They describe it, I don't know, it was like a decade ago or whatever. She got just tests to see if she had the gene, the Huntington gene. And the test showed markers that she does have that marker. That doesn't mean she's going to get sick. It just means that she has the marker. She doesn't have symptoms. She's not sick. She didn't go to a doctor. She's not being treated for it, even though there's no cure. I understand there's no cure, but she's not being treated for it or anything. It doesn't affect her life at all right now. Although she said, like the other lawyer said, I've seen you on the stand for a couple hours and you haven't, twitched or anything. She said that she does. Oh, she definitely does. But no medical doctor is working on her with this right now because it doesn't affect her.
Also talks about where applicable, the time necessary for either party to acquire sufficient education or training to enable them to find appropriate employment. Judge, this case is a little unique in comparison to other cases where we have a stay-at-home spouse and parent and a need for rehabilitative alimony as it relates to maybe education, et cetera, re-entering the workforce. The goal of alimony is to be rehabilitative, certainly. That is a factor, and it is not to be punitive. I agree with counsel, so we have another agreement there. But we have to look at the circumstances as a whole, and the factors outlined in 1965 are not exclusive. They are guiding factors. The reality is, even though Mr. Satterwhite testified he would pay for college as long as she didn't go to Harvard, we can't have the best, but as long as she didn't do that, he was willing to pay for it. The factors are different in this case, or the circumstances, regardless of what education my client obtains. And although on cross, when asked why she was bothering to go to school, if she believed she had a shorter life expectancy. She said, it's always been a goal of mine. My client's a hard worker, whether it's in the home, in her personal endeavors, in her children, in her community, and giving back the money that she's withdrawn from the account to backpack buddies, to White Christmas, to building a playground at the elementary school at Walker Mountain. She's a hard worker, and she's invested in everything she does. And regardless of what her education is, what job we could find her to walk out
She's a very hard worker, guys.
the courthouse today, her reality is she's planning for something different than another parent or spouse in a different case who just needs to get that degree, who just needs that entry-level position. That job only has a short window of utility based upon the uncontroverted evidence that she's going to have to plan for given her illness. And that is something the court cannot ignore. That is a reason we are asking for lifetime alimony, which is absolutely appropriate under the statutory framework. The courts also look at contribution of each party to the marriage, services rendered in homemaking, childcare, education, and career building of the other party. Those factors are here. Some of the charges on that American Express for games like Prodigy and Barnes and Noble, things of that nature. She testified, well, those are educational games. That's an app for Oliver so he can learn, or that's this, that's that. So she absolutely has satisfied those factors of the alimony statute. Statute also requires the court to look at the conditions of the parties, their separate estate, their earning capacity, fixed liabilities, key factor in this case, and any other relevant factors. We've heard so much about debt, Judge, so much.
I agree with the value of a homemaker. If you're in a marriage where the income allows it, but you have kids, and she's a grown adult and she has kids, and she's getting a divorce. So you have to get a job. We all have to work. Everybody has to work to earn money.
Why do we have this debt? Well, we had paid off vehicles when the case was filed, so we didn't have vehicle debt to the tune of $80,000. So who did that? Mr. Satterwhite. We had a mortgage. We still have that mortgage. Okay, so we would have had that debt still.
This only lasts a second. I start grabbing my computer here and worrying. I was petrified that I just lost the verdict. So I start clicking around. Then it comes back on.
We have credit card debt. Lots of it. All but one card, every time it was pulled out of the wallet and swiped, or Apple Pay was hit on the phone, or some other format of utilizing those cards, the plaintiff in this case made that conscious decision. So if we looked at the fixed liabilities, when we started this, it was around $280, and that was that mortgage on the marital residence, plus a few other smaller debts. Nothing as substantial as what we have now. We've heard a lot about how he just can't afford, Judge, folks that just can't afford they don't spend $2,500 on tattoos. They don't go to the vape store in every city they travel to and a couple times a week in Gainesville. They don't buy bands, gifts from liquor stores. They don't buy friends that they stayed with 2 years ago or a year and a half ago, liquor-based advent calendars as a Christmas gift. They don't go to all these different places, timeshare or not. They make decisions like, hey, we should sell that timeshare because we can. Hey, do you want to sell this? This would be a good idea. This would help us get out of this hole. Nope, swipe it. That's what we have done in this case. Looking at child support, Judge, the court is well bathed in the statutory framework of 19.615. I'd like to draw the court's attention to the proposed child support worksheet of the defendant for a very specific reason. Two parts of one, there is believe it's in the comment for court section, front page, right corner, of the $39,000 figure for the plaintiff should be a floor or a base. And that was directly from documents that were being filed by the plaintiff. His income has bounced all over. There's been worksheets that say 31 and then 39. And so we chose that one. But that floor is there for a very specific reason. That's also the reason for a lot of other things in this case. We didn't really know what he was going to say because it's changed so much through his pleadings, his affidavits, his experts. Paid $21,000 for an expert to provide a report in August, but we didn't bring that. Oh, that's old information. That's not important. We wasted $21,000 on something that is no good. That is so shocking to me. That is shocking that we didn't even take it into consideration and at least add on to it. But the worksheet, he confirmed today or this week through his testimony that he's never sought to amend those tax returns. I think that's important, Judge, because he has filed those returns as the sole owner and operator, financial officer, every aspect of those businesses. Mr. Satterwhite has gathered and provided that information to be put into a tax return filed with the federal IRS, the Georgia Department of Revenue, and the other states that are listed in there in which he worked and filed taxes. That is the exact same thing from the defense's perspective as swearing to tell the truth, the whole truth, nothing but the truth. When you file your taxes, you're supposed to be telling the truth. He confirmed that he's never sought to amend those, but for his testimony, the defendant was unsure of what he may say. So now that we have that, drawing the court's attention to the worksheet, 2022, 2023 taxes list incomes, various incomes. One of them is in the 500,000 range for VACO, the other's in the 400. I can't recall the exact figures, but they're in evidence, plus the gross receipts and ordinary business expenses that would be for the other two businesses. So I believe that's right for the court to decide. The court is not bound by what an expert says, even if an expert is tendered. The court has to give weight to the testimony, looking at the principles of the Daubert standard. And the court is not bound by what an expert says. And frankly, the plaintiff doesn't agree with what the expert says. The tax returns don't. None of it reconciles. But what we do know is that those tax returns have not sought to be amended, and they have the highest figures in there for assets. They have the highest figures for income. And a key piece of testimony that from the plaintiff was that he has $0 in business expenses as a self-employed person and a 1.75% owner in VACO to generate that income. 19615 is very clear on how.
I don't know, Linus. I just ordered groceries and I don't really want to be independent anymore. I think I'm done being independent. I think I need a 2-income household.
The court is to address self and
I'm scared to restart because I might lose the whole stream. All right.
to be considered as they are distinct from the tax code. So the court may choose, if the court is inclined to increase its findings on plaintiff's income, I would direct the court's attention that is distinct from the request that the defendant has made in our worksheets. And here's how. Excuse me. Under the high income deviation section of 19615, it provides if the parent's combined income exceed $40,000 per month For high-income parents, the court shall set the basic child support obligation at the highest amount allowed by the basic child support obligation table, but the court may consider an upward deviation consistent with the best interest. On the bottom of the table, the very last line, if you go to $40,000 and go over 2 lines to the 2 children section, the child support obligation would be $4,736 per month if the court finds a combined income of 40,000 or more.
Microphone off over there, or pull it down. I think it's just standing in between was catching, but that's all right.
Okay, I was
Sorry
wondering what
about
that was. Yeah, absolutely. So if the court is inclined to find a different number for plaintiff, we would ask that the court follow the high income section. Otherwise, we would ask the court to adopt our child support worksheet. I don't know if moving will help. Judge, my client is asking for $7,000 a month in alimony. She explained the
That
unknown
sounds like it's
variables,
safety option.
equipment, therapies, lack of insurance having been denied 4 to 5 years ago, as well as, projected in the future. Presumably, it's reasonable that inflation would be part of that consideration and needing to plan for that. Lifetime alimony without condition is not a windfall, as the plaintiff would seem to suggest. It's a life raft for my client, and in this case, it is the only just outcome. Alimony exists to correct the imbalance when one spouse walks away with a career, benefits, a bank account, and the other walks away with the scars of sacrifice, and in this case, also a terminal illness. Plaintiff likes to discuss what he's paid for, but let's look at what she has invested that she's asking the court to take into consideration in equitable division as well as an award of alimony. She's invested her life for this family. She hasn't invested in a 401k or equity portfolios, but in raising children, running the home, and supporting a man that now claims he should not be responsible for her anymore, and she needs to remove herself from his hip. Alimony is not a handout. It's a compensation for the years she's invested in building the very life that he now claims is solely his. She's not asking for luxury. The court often hears a request for alimony based on the style of living that one has become acquired to, of traveling to and fro, and they should be able to continue to do that, Judge, because that's what they're used to. Certainly that's a factor here, but it's a nominal or otherwise minority factor. Again, this is a necessity that my client needs to be able to prepare for the future that she's testified about. Mr. Satterwhite speaks of alimony like it's a punishment to him, a life sentence. But the punishment's already been served by Ms.
No, he
Satterwhite.
doesn't.
Her silence, her service, and now in her illness. To him, cardboard trading cards hold more value than the woman who has held his children through the night, supported him in his businesses, and sacrificed her independence for his ambition. Conduct is relevant not only in alimony in determining whether the spouse should be awarded alimony, which has not been complained of here, but it's relevant for equitable division. There is a plethora of case law in Georgia discussing conduct. Equitable does not mean equal. Those are all things that are found in cornerstone cases in Georgia law discussing conduct. The spending conduct, the violent conduct, the hide and seek games in litigation, all of that is conduct. And that's why my client is asking for a 60% award of equitable division.
I was told that I might have had to pay alimony. And that just doesn't make sense to me because he was perfectly able to work. At points during our marriage, he did work. But there was nothing stopping him from working. He was not a stay-at-home father. He did not care for the children. And if he would have asked for it, if he would have fought me, I would have had to pay him alimony. And that's just crazy.
Because conduct is absolutely relevant, and Georgia is not an equal state or an equitable state. My client testified and is outlined in the defendant's hearing request. She is asking to be awarded the marital residence. She is asking that the husband be given a reasonable time frame set forth by the court, but if the court is to adopt her request, it would be within 1 year to satisfy the mortgage on the marital residence. Each month, she would
20
pay
years.
that money
20.
directly to Mrs. Satterwhite, so she can ensure that her credit is protected as it is a jointly financed, jointly deeded piece of property. And she would then, in turn, pay that to the mortgage holder, which is presently Mr. Cooper Mortgage. The first tax season, as far as property taxes, following the satisfaction of the mortgage that encumbers the property, Ms. Satterwhite would be responsible, for the mortgage and insurance, but presently they're escrowed. So that is not an issue, but she's asking the court to set a time frame in which he is to satisfy that, which ordinarily would be a difficult or tall task. But in this case, we just have to look at one of the 6 or 7 stacks of documents to my left and see that if he just cuts out a few of his habits, this will be an easy feat for him. And he can make his way to that freedom of financing another house with a new girlfriend. That's his latest addiction. It's his newest gamble, his newest obsession, just like the unboxing. It's the equivalent to gambling to an addiction, Judge. This is not a difficult task for him, and we're asking this court to award my client all equity, possession, ownership. He can have the big green egg. He can have the toolbox with the tools in it.
I mean, he gave me monthly floppy disks, so I guess it would be fair.
He can come get his equipment, the music equipment. Those are not an issue. Let's set a reasonable time frame as and outlined in the court order, so we don't have to negotiate about that. Come get it, no problem. Counsel for the plaintiff is, the defendant is specifically asking for a finding that the payment and satisfaction of the $288,000 mortgage for the marital residence, that is how the defendant is asking for the court to address the dissipation of marital assets in this case by the plaintiff. So he has went ahead and took some of hers that she could have, as she's testified. That's why we filed the motion. We knew this was going to happen. He bought cardboard. So to remedy that, she's asking for him to pay the entirety of the mortgage, and that would be the satisfaction of his misdeeds and misuse of funds that this court has the jurisdiction to equitably divide. If there are any utilities that need to be transferred from plaintiff's name to defendant's name, we would ask that the court set a reasonable time frame and method for that to occur, so we don't have to negotiate and address that either. The timeshare, my client does not want it. She has no qualms with the husband being awarded that, but he would be responsible for any fees. But he's testified that it's
Oh, I love
available to
that.
be
I
sold.
love that, Eric.
So that's within the court's discretion. That's where we'll leave it. The stocks, there was testimony from the defendant that her husband told her they were worth $1 million. I didn't hear any redirect or rebuttal evidence from the plaintiff's side of this case contradicting that. There was a lot of I don't remembers, I don't recall, I'm not really sure. Tax returns say one thing, documents say another, but then we get a spreadsheet this morning that places a $600,000 balance. So we're asking this court to value those stocks no less than $600,000, but we're asking the court to assess them at $1 million value and award her 60% of those. Uncovered medical expenses, Depending on how the court finds as to plaintiff's income, we would ask that any uncovered medical expenses be shared pro rata. Commencing immediately going forward, the out-of-network counselor is an expense that's not covered, so that would be a pro rata share. But the children shouldn't be removed from their counselor they've been with for over a year because it's a financial inconvenience to whatever the plaintiff's next spending habit is. We would ask that that remain unaffected. Debts, defendant is asking this court to assign responsibility of her student loans to her and all debt in the husband's name to him for the reasons that have been argued and are in evidence. Husband would continue to pay health insurance and the premiums. The Fidelity 401k account, which has a balance of approximately $45,000 to $47,000, we're asking that the wife be awarded that. She would open a qualified account with Fidelity within 30 days of entry of a decree and allow that the funds from the husband's 401k be transferred to the qualified account of the wife that she would open. There was a proffer that plaintiff would pay for any fees necessary. I'll state in my place that Fidelity has a Quadro Center. It's a relatively simple process. So not going to be very expensive at all to figure out, Judge. Let's see. Make sure. The businesses, client doesn't want the businesses, Judge, but the businesses are a marital asset. There's not been any assets or property that have been argued to be mixed or separate property, and that's the first task of the court, is to address that all of the assets of the marital estate are in fact marital property. So the businesses are marital property. They were formed and operated during the marriage. There's a lack of credible evidence, again, as it relates to the values of those businesses. Tax returns say one thing, sworn interrogatory responses filed last week say another, and leave off a business. The Nicholson Group, they got something, but they just didn't include it. They don't really have a lot. So what I would encourage the court to look at is the tax returns. Again, those two documents that were filed with the state and federal governments as it relates to the assets and the income of those businesses. We're asking that the court take an average. Plaintiff says they're worth 200. Tax documents say around 550,000. My client testified there's probably some depreciation there, not to the extent he's testified. So take the average, value the businesses, the two music businesses as $375. If the court doesn't have sufficient evidence, or take the tax return document. We don't have anything else to say otherwise. We have an Our Family Wizard message that's in evidence that was put in by the plaintiff, where the preparer of taxes says that there's a value. Court could certainly look at that number. I believe that's in the $400,000 range. Conveniently, that person wasn't here to testify. We paid somebody else $40,000 to come in and say what USAA, Chase, American Express, and the tax preparer since 2021 could have said. Why? We'll leave that up to a credibility issue, Judge. So we're asking for an award of 60% of the value of the businesses that the court assesses. The court at the outset of this case inquired of counsels for both parties as to the court's discretion in non-modifiable alimony. And it was somewhat fleshed out, but to readdress it, the court cannot unequivocally, unless there's an agreement, do non-modifiable alimony. However, there is case law that addresses the appropriateness of alimony for lifetime and the removal of a provision that remarriage or cohabitation would be a termination. So the court absolutely can award my client lifetime alimony and can remove the provision about cohabitation or remarriage as a terminating factor. The case of Clements versus Clements, which is 255 Georgia 7.
Wow. Wow. I just had to step away for a few minutes and it didn't do this. And as soon as I sit back down, I'm glad I came back. I had to step away though. I had to. Stop sharing.
From which to satisfy such award. Spouse's award of tangible property could be used to satisfy the cash award. So in Clements, there was probably a similar argument. We don't have any money. We have all this stuff, but it's not worth much. That case awarded the wife a cash amount and the other spouse the tangible property to figure out how to satisfy the award. And that is perfectly appropriate for this court to do. Property acquired as a direct result of the labor and investments of the parties during the marriage is a marital asset. That's Shaw versus Shaw, 290, Georgia 354, 2012. Plaintiff rests upon that wife did nothing but raise children. Therefore, this is his
almost
money.
done, I think.
His coattails. These are arguments he's made. But Shaw says differently. It's all marital. In Wire versus Wire, which is WIER versus WIER 287, Georgia 443, says a final decree awarded the wife $200,000 as a lump sum property division and $600,000 as lump sum alimony. Neither were error because evidence supported that marital property was in excess of the amount. An award is not erroneous simply because one party receives a greater share of the marital property. Lump sum alimony was not excessive where evidence showed husband owned property valued at more than $1.6 million and his income was more than $16,000 per month. Significantly less than what we have here, Judge. In distributing property, the court has broad discretion to award assets
1 more hour long.
in whole, part, or to require property to be sold. That's Jones versus Jones, 264, Georgia 169. Equitable division of property is distinctly different from alimony as it is an allocation of assets acquired during the marriage to the
She
parties
is asking for all of it.
based upon their respective and just interest in those assets. That's Frost versus Frost, 299, Georgia 278, 2016. In Courtney versus Courtney, which was 256, Georgia 97, the wife was entitled to an equitable division of the husband's unvested retirement benefits to the extent that such benefits were acquired during the marriage. That's important because if the court finds credibility in portions of the plaintiff's testimony, he testified that those stock options will not vest until and unless the company is sold, despite other evidence that shows some of those have in fact become valuable. But Courtney allows the court to address future unvested interest. And that can be in the form of an equitable division or in the form of support by awarding a percentage. Size Joint Venture, SEIZ Joint Venture LLC versus Size, 290 Georgia 719. By awarding the wife a 1/6 ownership interest in the company, the trial court did not illegally require the company to admit wife as a voting member. In that case, it's a distinction a bit. It was a family company, but the point, and that is persuasive in this case, is the court has the ability to address the husband's ownership interest of 1.75 as a marital asset. Despite having categorized by the plaintiff of temporary support or that marital pie, as I discussed, it's actually improper for the court to consider that. In Grimm versus Grimm, as well as Horton versus Horton. Grimm is 268, Georgia 2. Horton is 288, Georgia 217. Both of those cases discuss there's no evidence of temporary support that should be considered. So that was one of the motions in limine that were addressed when we were scheduled for a jury trial up until less than 2 weeks ago. But it's also not appropriate for this court to consider in determining equitable division and alimony. Lanier versus Lanier, 278, Georgia 881, discussed tax returns being relevant. Anthony versus Anthony, 237, Georgia 753, discusses that an award of real property as alimony is proper. So the court has a lot of discretion and ability to address the marital residence. A few final concluding remarks on income and then the attorney's fees.
I know she said a few final concluding remarks, but
there is a case that came out, and frankly, one of the reasons I didn't have any questions for counsel when he was stating in his place his skill set and his appropriateness, and I agree. He appealed a case of, I think it's Yellen versus Welch, 371 Georgia Act 558, 2014. Specifically in that case, the one enumerated error that the appellate court found had merit was that the trial court needed to consider assets as well as actual income. It wasn't for the trial court to go outside of the scope of the intent of the General Assembly. So the child support statute specifically discusses income, what is considered income, as well as other assets that may be used to generate income for the support of the children. And so that case, I believe, is directly on point here, as the appellate court held that the court should not just look at the revenue or the income, but the assets available in that prevailing case. The last point that I would address would be the fees. Judge, everybody has pulled from the marital estate to pay their professionals. The plaintiff admitted, and the evidence is clear, both parties have spent about the same amount of money.
no, they didn't. She did make some really good points, because you got to remember, all the judge cares about is the legal part of this, the law. And she did make, she made some really good points with the law. She made stupid points with other fluff that he's just going to ignore.
If we look at Nicholson plus McCormick or Fox Chandler plus Kimbrell, we simply didn't hire an additional person to do summaries and form opinions about values that were already in documents that we were exchanging in discovery. Instead, for the defendant side of the case, the attorneys employed to represent did that work. And in fact, the counsel for plaintiff also did that work. So there was duplication on the plaintiff side of this, but to suggest that there has been an imbalance is contrary to the evidence. The amendment to the complaint for divorce, I believe, is procedurally improper. With respect to the relation back doctrine, I believe that the amendment to the complaint goes back to request fees under 1962 and I believe 9/11/37, based upon circumstances that have occurred since the filing of this case, that which are distinct from if somebody amends their complaint to say adultery now. If they discovered that through the discovery process and they wouldn't have otherwise known, that's a distinction from, well, I spent a lot of money on this, now I'm going to ask for it under 1962 or 9/11/37. That's not, from the defendant's perspective, how that works. There's not been the first good faith letter sent in this case from the plaintiff to the defendant, a motion to compel not filed. So 91137 is severely misplaced for the plaintiff to request fees. However, 91137 does discuss the court's ability under 3 prongs. The first prong is if the court grants a motion to compel, the ability to award fees, denies a motion to compel, the ability to award fees. And then the third prong is if it's grants in part, denies in part. I thought we had addressed all the discovery issues about a month ago, but we discovered this week that we were being told we had everything. We were ordered to have everything in 10 days. Unfortunately, we didn't. So the court can, under 91137, sua sponte, address fees under 91137. And the court will find in Defendant's Exhibit D-10, which are my detailed billing entries through May 10th, that it's very, very detailed as to the work that was expended by my office in the pursuit of the motion to compel. Certainly there were fees by her former counsel in all the good faith efforts. Those are not requested. The court has the discretion there to go through and assign fees under that statute because it is right. Under 1962, the commonly referred to the leveling the playing field
Boston
statute
Sting
judge for fees.
Boston.
Candidly, I've never had a case where someone who makes from their tax returns over $500,000 a year plead from a homemaker a request for fees under 1962. I'm not sure of any case law that supports that, but nonetheless, 1962 is within the sound discretion of the court, except that the court shall consider the financial circumstances of the parties. So we would request a denial under that statute as pled. It's without merit as well. The defendant could certainly, any outstanding fees could be apportioned to the plaintiff in this case under 1962 for the defendant. The other two,
I'm not going to tell you who, but I am going to tell you one of them gets really mad with the outcome.
appropriate statutes that the defendant, if the court is inclined to address fees or reapportionment, would be under 91514A and 91514B. We did file a motion.
Judge, sorry to object. There is actually no motion for attorney's fees under 91514 filed. She filed a responsive pleading asking for fees. So,
And I tell you, I'm ready to rule.
Okay,
I think I've made up my mind. So,
perfect. Thank you, Judge.
yes, ma'am. And I may need some help, okay? Because I'm not saying I'm infallible here. The things that I think the parties have agreed to is setting Mr. Satterwhite's income for child support at $39,341. That's what he put on his child support worksheet. I think the wife has agreed to that. And the only offset or deviation for that was for the insurance. And even though I know that the defense put it half of what's paid monthly, I've corrected that and included the entire amount that's paid for insurance for the children. So it's, I think it's $1,656 a month. And I'm going to give Mr. Satterwhite credit for that because he's going to continue to pay for the insurance for the children while they're subject to child support. So I think the parties agreed to those two numbers anyway. Ms. Satterwhite, I did impute to you minimum wage, working 40 hours a week, which is $1,305 per month. And I believe that you can work 40 hours a week, making minimum wage. And so I've imputed that to you. So based on that, the child support amount that Mr. Satterwhite will pay monthly is $4,531. And I'm assuming that those numbers are not contested because y'all agreed to what his income was and the insurance. That was the only number I had. So I don't see that being a basis for an objection. I'm gonna address some more about that, but let me talk to you a little bit more, just in general, okay? And I guess I'm gonna start off yelling a little bit, and then maybe I'll come back around. Mr. Satterwhite, I think the testimony is clear that you committed an act of domestic violence. I think you admit to that.
Yes, sir.
Whether it's a criminal offense that you'll be convicted of or not, I think you admitted that you struck your wife during an argument, and you can't do that. And it's probably to have any bearing on this divorce, and probably none of my business, but I'll just tell you, and you don't be
The act of domestic violence has no bearing on this divorce, he just said.
don't need to be vaping, especially CBD and that kind of stuff, if you're under the treatment of a psychiatrist and taking medication. Do what your doctor says. Don't try to self-medicate. I think that just causes problems. Plays no role in this divorce, but that's just my 2 cents, okay?
So his vaping has no bearing on this divorce.
And for Ms. Satterwhite, just a couple of things. I was pretty concerned and disturbed when I saw that Our Family Wizard messages where you were making monetary bargains on how to deal with Mr. Satterwhite's criminal case. There's actually a statute called compounding a crime, and you got real close to that if you didn't step over the line. And I don't think you knew that. I don't know that you understood that, but you can't do that. And I didn't appreciate that conduct, because criminal and civil are totally separate. And the state prosecutes the case, not the victim in a criminal case. That being said, I hope y'all get that worked out. Also, Ms. Satterwhite, I was disturbed that you were taking cash withdrawals and putting it in a bank account, not telling anybody. I didn't think that was appropriate conduct.
Extortion is compounding a crime.
And took a bit of umbrage to that. Understand your reasonings why. Understand why. Just wasn't what you were supposed to do. Just like, and particularly like it that Mr. Satterwhite took and charged $60,000 or so on the credit card to buy cards for his business. I understand why. I mean, because you're making your business. I understand why. That's just really not allowed under the rules of a pending divorce case without talking to the other side. So maybe you didn't follow the rule like you were supposed to. And so I did take note of that. So anyway, getting back to child support, based on the child support worksheet, the pro rata share is 96.79% to 3.21%. I'm going to massage that a little bit and say that for uncovered medical expenses, Mr. Satterwhite will pay 95% of uncovered medical expenses, and Ms. Satterwhite will pay 5%, unless medical care is provided out of network to a doctor that's not agreed to by the parties. And if that's the case, then Ms. Satterwhite will pay 20% and Mr. Satterwhite will pay 80%.
Okay. So the kids are all in counseling. It's $2,000 a month for the counseling because they're out of network. He just wanted them in network. The wife says, no, we're staying with this. The judge just said she has to pay 20% of that.
So she has to pay more if she decides to take the children to a doctor outside the network that you didn't agree to. Because like you said, I think in your testimony, you said if there's a specialist and there's not one in network, I don't have a problem with that. I just have a problem with there's plenty of counselors. Why is she taking them to the one that's not in network and I'm paying $2,000 a month? And I agree with that. And I support you in that. I'm making her pay more if she chooses to do that over your objection. That being said, I am going to require that Mr. Satterwhite, you're going to pay for the next 4 sessions for these children with the current counselor they have. Because within 4 sessions, y'all either work out a transition plan to get them to a psychiatrist or counselor that's in network, or you figure out how you're going to pay 20% of the cost, because Mr. Satterwhite, he's going to pay just like he's been paying for the next 4 sessions. That seems fair enough to make a transition. But after that, either get them to a counselor that's in network, or the cost changes and you'll pay more, Ms. Satterwhite. I believe Mr. Satterwhite during his testimony and in your closing said he would agree to pay 90% of the extracurricular activities outside of the child support worksheet. And so that's what I'm going to do by agreement of the parties. He'll pay 90%. Ms. Satterwhite pay 10%. Mr. Satterwhite said he would pay 100% of the child care. I was a little worried about that, because what if Ms. Satterwhite said, well, I think they ought to go to Maranatha Christian School and it costs, more than it costs to go to college. So I took the numbers that were provided, the only numbers I really had of what child care was, I think at the Cleveland daycare or something like that. So Mr. Satterwhite, here's what we're going to do. You'll pay 100% of the child care costs, like after school kind of stuff or daycare, up to $220 a week. It caps at $220 a week for 2 children. When we get to 1 child, it'll cap at $110 a week. And
Nice
sure,
job, Judge.
Your son gets off your child support guidelines, there won't be a need for any after-school care at all for your daughter. But it caps at $220 a week. So if Ms. Satterwhite decides she wants to go somewhere more expensive, she's going to have to pay the rest, because you're only paying $220.
I don't know, Judge. Are you saying you don't trust this woman? Do I hear that you think she might spend money that she doesn't have?
Also, whoever's going to prepare the order on the child support worksheet, I would ask that you prepare a second child support worksheet for 1 child. So when Oliver ages out, because he'll age out when he becomes emancipated, when he turns 18, or when he graduates from high school, right? So he may be 19 by the time he graduates high school, but whenever he's 18 and graduates high school or he's emancipated, child support would end for Oliver, and same for Olivia once she gets to that age. But instead of you having to come back here later and say, I need to modify child support because I'm still paying for 2 kids and one of them's in college, you won't have to do that. We're going to do 2 child support worksheets. Does that make sense?
It does. Does there need to be a change in the health insurance deviation?
I'm assuming not, because the way I took it was you pay that amount for a family, whether you had 1 kid or 10, it's the same amount. That's the way I took it. So
Okay.
I assume it's the same. All right. As far as property, Mr. Satterwhite's going to get all of the collectibles, the Toy Story toys, the cards, all of those things that are at the residence. Mr. Satterwhite, you're going to get those things. And I think you said there were some figurines, there was cards, there was Warhammer, something hammer or something.
Warhammer 2,
you get all
Judge.
those. You also get all the video games and the Apple TV, music, all that stuff. You get all that stuff. I looked at this asset sheet, the marital balance sheet that was provided to me, and let me go through this. Well, I guess before I do that, let me just say this. As far as I find that the grounds for divorce are there, that the marriage is irretrievably irretrievably broken, no chance of reconciliation. While I do find that Mr. Satterwhite committed an act of domestic violence, I'm not going to find ill treatment. I'm just going to find the general grounds for divorce.
What? You mean he wasn't cruel? Are you saying, Judge, are you saying this man wasn't cruel to her? For real?
You know, there's been a lot of debate about y'all's relationship and who did what in the marriage and that sort of thing. And I'd be remiss if I didn't say this. Maybe I should have said it at the beginning of this thing. Maybe it made it a little shorter. This is the way I look at a marriage. You know, at some point during your relationship, y'all decide what roles you're going to play in the marriage. And I've handled a lot of divorce cases, and I always say, look, it's not fair.
That's it. If I ever get married again, I'm putting that in the marriage agreement. If we ever get divorced, you have to supply me with Jell-O pudding pops for life. You have to. That's part of the marriage.
It's not fair for the wife to say, hey, I stay home with the kids, and dad never sees the kids because he's at work all the time, so don't let him have visitation or custody of kids. Well, that's not fair, because that was the agreement that you made in your family, that your wife was going to stay home and take care of the kids and dad was going to work to make the money. That's the way I grew up. You know, my mom stayed at home with the kids and my dad worked. Likewise, it's not right for the dad to say, well, mom's sorry, she's not working, she doesn't make any money, and I'm working all the time, because that was the agreement y'all made. You would go to work, she'd stay home and take care of the kids. And so I have lots of cases where that goes on, and it's like, it's not fair for either side to say that. It's not fair for mom to try to keep dad out of the children's lives because dad didn't get to go to every ball game and doesn't know the name of every teacher. It's because they're working, and that was what y'all agreed to. Likewise, it's not fair for dad to say, well, I make a lot of money, mama doesn't make any, when that was what y'all agreed to. And so, you know, as this divorce has gone on, as y'all have made your life together, as you've moved around the country and worked at different jobs and had your children, and even when you separated, y'all were still working off of a marital pot. And I think, you know, there are a couple times we've had hearings where I've said, it's all coming out of the same pot. At the end of the day, it's coming out of the same pot. And that really is the way I see it in a lot of ways. Whatever y'all gained while y'all were married together is a combination of the two people. Y'all have joint ownership of that, because what Ms. Satterwhite did to take care of the kids allowed you to do all the stuff that you're doing. And you were able to do all the stuff you were doing because you weren't having to take care of two children. I'm not sure which one. I might choose your course rather than hers. I don't know that I want to stay home with kids all the time. But it's an agreement that you made. And I will say this, Mr. Satterwhite, and Ms. Satterwhite, you should recognize this too. Mr. Satterwhite is a hard worker. He's a hard worker and evidently wicked smart, because I'm thinking, how in the world did he come from working in the grocery store to he's making all this money and has all these stock options? He's over here talking about stuff I have a very hard time understanding. And I have no doubt that you're going to be very successful in what you do. You are successful in what you do. And you should applaud that, because his success is helpful to you and to your children. I mean, ultimately, your children are going to benefit from dad being successful. And so I don't think you should be ashamed of what you do and how you make your money and how creative you are to do that. That's an admirable thing. Ms. Satterwhite, I heard the testimony about your concerns about your health, and I take it at face value. Even Mr. Satterwhite said, you had a test, you have this genetic marker, this genetic trait, and the way I took that is, that means eventually you're going to get sick and have these issues. Maybe not dealing with it now, but it's coming, is what it sounds like. I've considered that somewhat, but at the same time, I kind of have to look at the facts as they are today. what I would encourage you to do, and it's easy for me to say, right? Because I don't have to deal with this. But I hope that you'll consider every day as a blessing, and you should plan for the worst, but hope for the best, and try to make every day you can as full as you can make it. All right. So I think I digressed there. I went through the spreadsheet, and here's what I have decided. I'm going to find that
I feel like somebody should get a calculator out, but you don't really have to because he's going to add it all up at the end, and he goes too fast. But try to pay attention. Try to listen for a second. Just ignore chat and try to listen, or you're going to have questions later. Like, what did he award for that?
Toyota Sienna's worth $36,978, and it's going to be wife's property. And Mr. Satterwhite, you'll do whatever it takes to get that in her name, get the title in her name, all that stuff. You'll be responsible for the insurance, Ms. Satterwhite, as your vehicle. You're going to be responsible for all the upkeep. The 2012 Toyota Prius, I find is worth $5,961. And the Toyota Sequoia 2024 edition is worth $71,926. And those are both going to be awarded to Mr. Satterwhite. And Ms. Satterwhite, you'll do whatever is necessary to make sure those are put in his name. And you'll be responsible for all the expenses, the insurance tag, all those things, Mr. Satterwhite. On the businesses, I think that Mr. Satterwhite, these businesses, from what I can tell, these businesses are dependent on Mr. Satterwhite. It's not like a gas station that you could sell the gas station, somebody else could come in and run it and make money. These businesses are only valuable because Mr. Satterwhite's running them. I mean, anybody could go buy collector cars. Mr. Satterwhite's somebody that evidently can make a lot of money off of that, which, if you said, Judge Deal, you go do that, we'd go broke real quick because I would have no clue. So, I'm not going to split up those businesses because I think the only person that can make those things work are Mr. Satterwhite. So, Mr. Satterwhite, I'm going to award you complete ownership and interest in Dark Sales, Maelstrom Studios, Cardboard Addict, the 2019 Ford van, the USA Maelstrom Studio account, the Dark Sales Studio USAA account, and the Venmo account for Maelstrom. And the only thing I varied off of the evaluation on all this was that, I found that Dark Sales Entertainment's worth $10,000, as you allege in your spreadsheet. I found that Maelstrom Studios equipment, that's all of the music equipment. You put on the spreadsheet $200,000. I noted on your 23 tax return, you had it listed as like $448,000 and change. And I heard some other testimony about the value of the equipment. I know there's been some testimony about whether it's a fire sale or not a fire sale. And I think the appropriate way to value stuff is worth what a willing buyer and a willing seller would agree a cost was. So not a fire sale, not a duress sale. I'm going to assess the value of the studio equipment at $400,000. For Cardboard Addict, I assessed the value at $70,000. I think there was testimony you spent $60,000 to $70,000 on inventory. You had $20,000 of inventory for sale. And I know that you don't make any bad investments, so it's got to be worth $70,000. The 2019 Ford van, I assessed at $18,000. That was in the middle of what your expert said the price was. So I assessed it at $18,000. The accounts, the USA accounts for Maelstrom and Dark Sales, they are what they are, $3,869 and $689. And the Venmo for Maelstrom's, what you said it was, $4,351. The marital home, you all both presented different values of what you thought the marital home was worth. I noted on the spreadsheet that Mr. Satterwhite had $554,300. I note that that exceeded even what his expert said. I think his expert said they listed at 480,000, and that it had a value of somewhere around 450 to 480,000. I believe that Ms. Satterwhite had the tax assessments were less than that. So I'm gonna set the value at 450,000 for the marital home, and I'm gonna award that to Ms. Satterwhite. On the financial accounts, there's the USAA savings account for $729. That'll be Mr. Satterwhite. The two tax accounts that have $478 and $1,700, those will both be for Mr. Satterwhite. The USAA checking, $22,469, that'll be Mr. Satterwhite. The cash out with $53.01, that'll be Mr. Satterwhite. And Ms. Satterwhite will keep the $17,000 in her Peach State Bank account. As to the retirement accounts, Mr. Satterwhite's going to transfer to Ms. Satterwhite the Fidelity Vaco 401k that's worth $44,241.56, and the USAA annuity that's worth $6,647. And he'll pay the cost and do what's necessary to make those transfers to Ms. Satterwhite within the next 30 days. And he'll maintain his Fidelity Vaco health savings account. I think that's what that is.
Yeah, it is.
$388. As for personal property, Mr. Satterwhite's going to keep his toolbox. He'll be able to retrieve that from the house. And I just assessed the value of what y'all put on there, $300, the green egg, $800, the video games, $2,000, the trading cards at the house, $5,000.
In case you missed it, guys, in case you missed what just happened right there, he got the green egg. He won the whole divorce. He got to keep the green egg.
The guns at $5,000, the collectibles at $7,000. All those things will go to Mr. Satterwhite, and he'll get those within the next 30 days. Mr. Satterwhite, you just need to probably get somebody to help you with the firearms just so you don't run afoul of your bond conditions and get that squared away. And Ms. Satterwhite will keep the furniture that's in the residence. I think y'all assessed it at $14,000. As for the
we just slid right past the part where she got his whole retirement account and went right to the green egg.
liabilities, Mr. Satterwhite had agreed he would take the Green Sky Solar at $24,047. The Fifth Third Bank, which is the note on his vehicle, $78,615. The SoFi personal loan of $76,873.34. The Chase Marriott credit card of $46,024. There's another Chase credit card that has a zero balance on it that will remain in husband's name, and Ms. Satterwhite, you'll not use any of those credit cards. The American Express Delta card with the $31,102.37 debt, Mr. Satterwhite to accept that. Discover credit card of, there's an American Express Platinum card for $268.49. Will be handled by Mr. Satterwhite, as will the Sweetwater credit card in the amount of $6,846.15. And Ms. Satterwhite, you'll no longer use any of those credit cards. You'll not incur any further.
Starting now, starting right now, she's not allowed to use another credit card.
Debt on those credit cards. Mr. Satterwhite, you'll do what you can to remove her name, and she'll cooperate with you to remove her name from those debts. There are 2 timeshares. Mr. Satterwhite, I think you testified one was worth $10,000, the other was worth $30,000. I'm going to award those to Mr. Satterwhite. And so, and then the only things left are the mortgage, which is $287,693.18, and Mr. Satterwhite's interest in Plantensive Solutions. And I know that it's been difficult to determine what the value is of Plantensive Solutions, his 1.75 interest. The number that I've heard several times during the testimony was that perhaps it was worth $1 million, but if it was liquidated, it would be worth $600,000 because you had to pay taxes.
Thank you, Sally. Thank you. Don't use the credit card. Judge is going to get you.
I'm going to assess the value at $1 million because I'm not requiring you to liquidate it. I'm not splitting it up. It's going to remain Mr. Satterwhite's sole property. And Mr. Satterwhite's also going to be responsible for the mortgage, the $287,693.18. Now, I did the math on all this. And in doing the balance sheet, if using all of those things, and wife will be responsible for her $1,500 student loan. So doing the math on all those things, if I was just to add up the debts and liabilities as I've laid out, Ms. Satterwhite would be in the black, $567.
He has a bunch of businesses, okay? I'll fix it. He has a bunch of businesses. In one of those businesses, he has like 1/10 of a share or 1 share or something like that, that they valued at $1 million. So the judge awarded that to him, kind of. More to come on that, if StreamYard will allow me.
$567,166.56. Mr. Satterfield would be in the black, $1,078,936.48. That leaves a disparity of $511,769.92. One second. So if I was to make the parties equal, that would mean that Mr. Satterwhite would owe Ms. Satterwhite $255,884.96 in order to get them equal. And that's equal. That's not equitable. That's equal. That would make them equal.
Beef stroganoff.
1 1 second. I had to do a little.
I'm working right now. What are you talking about? I work every day. I don't go to Big Dogs tonight, no. Unless my boys come in. My boys come in, then I'll run in. I got a squash team that comes in just to see me.
And so,
The judge said no, she has to pay.
what I'm going to do is I'm going to order Mr. Satterwhite to pay Ms. Satterwhite $255,884.96. Now, I know he can't just come off the hip with that. And so this is where I might need some help. I think the current interest rate today is 6.8% APR. I don't know if there's a statutory percentage rate or not. Maybe Mr. McCormick, do you know if there's a statutory interest rate, or can I just say he's going to pay it at the interest rate that I can determine this applies today?
I'm not sure, Judge.
All right. So I know Mr. Satterwhite can't come off the hip with that amount of money. So Mr. Satterwhite, you're going to pay that amount over 15 years at a 6.8% APR. So that means you'll pay monthly $2,271.45.
Say that one more time, I'm sorry.
$2,271.45 per month for 15 years. Now, I wouldn't be averse if the parties can agree to make that an annual payment instead of a monthly payment, because I know you said that you'd rather pay annually versus monthly for the because of your bonus situation and that sort of thing. So this is how I figured it out.
Hold on just a second. Let's.
So if you can't agree, you'll pay that amount, $255,884.96, and you'll pay it over the course of 15 years at an APR rate of 6.8%, which will be $2,271.45 per month for 15 years.
2,000, what, Judge?
$2,271.
I'm really thinking about getting remarried, guys. I'm thinking this is a good idea.
$1.45. And that'll start June 1st. As to alimony, I'm gonna find that it's appropriate to award alimony under the factors that are contained in 1965. These parties have been married most of their adult life. They got married when they were around 20. They've been married for 20 years, so they've spent almost as much time married as they have apart. And they've had a pretty good standard of living, especially in the last few years. Take into consideration the educational status of Ms. Satterwhite compared to Mr. Satterwhite and their earning potential, and the ability to perhaps improve Ms. Satterwhite's earning potential to become more self-sufficient, and also take into some account some concerns about her future medical needs, although I really don't consider that too much. I think I said this, I popped off and maybe I shouldn't have said that. I don't think Mr. Satterwhite's your insurer. I don't think that just because he married you that he's required to take care of you for the rest of your life. But I do think that alimony is appropriate. And so I'm going to award $4,000 a month in alimony for 180 months. And that alimony will terminate if you remarry. Okay, so 180 months. Know what I said? 180 months. That's, so 180 months, $4,000 a month. They'll terminate upon your remarriage if you remarry Ms. Satterwhite.
What about taking on a resident? Not just remarried, but because, you can choose not to get married and take somebody on, right?
Good question.
I'm following the statute. It says,
She can have as many boyfriends as she wants, and you got to keep paying.
shall terminate upon remarriage. So that's what I'm going to do. All right. As for attorney's fees, I've looked at this, and Ms. Kimbrell charges more than Mr. McCormick, or did in this case. I don't think that her fees were unreasonable. And there's been a lot of documents in this case, a lot to keep up with. I don't know that I fully understood all your financial situation. Maybe Mr. McCormick did, but only because you were there helping him figure it out. I think it took a lot more work for Ms. Kimbrell and Ms. Satterwhite to try to figure out the financial situations with all these businesses. As you said, your tax returns are super complicated because of all the payments to all the different jurisdictions and that sort of thing. So I'm not inclined to award attorney's fees to either side. I think Ms. Satterwhite might have an argument. She might have an argument that, look, I make less, I should be allowed to get some attorney's fees. But she got her attorney's fees paid out of the marital estate. Mr. Satterwhite might be able to say, well, Ms. Satterwhite spent more money than she should have on her attorney's fees. And maybe that's so, but both sides spent gobs of money, $148,000 in attorney's fees and costs for professionals.
These two people sitting here, she made more. Well, actually, I don't know if she made more. She charged more, but she's been on the case for a smaller amount of time because this woman had a different attorney before. $148,000 in fees. $148,000 in fees, these two.
And that sort of thing. And so I think both sides went heavy on the law side of things. So I'm not inclined to award attorney's fees. Likewise,
I don't have any money, Marty.
Ms. Kimbrell had asked about the bonus that was, she made a motion to freeze the bonus or have it put in somebody's account. And, I told you all at the time, I didn't think I needed to do that. I could deal with it in the final hearing. And I don't see a need to go back and parse that out. I think it all went in the marital pot. It all got spent out. We identified how some of it was spent for the business, and Mr. Satterwhite's getting the business, and he has that inventory. So I don't see a need to go back and revisit the motion on the bonus.
What do you mean mediation would have come up? She said, and I don't know if you were listening because it was kind of boring, in her long list of qualifications, She is a professional mediator.
All right. Is there anything that I should have covered that I did not cover?
2 points, Judge.
Yes.
I've done the math. I don't think it's possible that Ms. Kimbrell could have earned $20,000 since last week, which she charged for prep for trial and attending trial. So I would like an ask an order for an accounting and return from the credit card from Ms. Kimbrell back to my client. Second point, it's my understanding, Your Honor, is in addition to $720,000 in alimony, spread it out over 180 months, 4,000 plus 4,000 child support, that's 8,000. 2,200 towards the equitable distribution, and he incurring all the debt. He has to pay the mortgage on top of that every month for the next till it's paid off.
I'm insolvent.
So he's got, his name's going to be attached to the mortgage for the next 15 years. So I'm just trying to get my head around
The
that.
numbers we've put together, I'm insolvent.
Yeah, I get it.
Well, I don't, Ms. Satterwhite said, well, he should pay it off in a year. I don't think that's reasonable that he could do that. He can't come off the hip with that. But my thought is that he would be responsible for paying the mortgage until that debt is cleared, however long it takes for him to pay it. And that once the mortgage clears escrow, so once they get paid up enough that there's no longer an escrow, Ms. Satterwhite would be responsible.
Just so you know, he's done. He rolled, and there's still 14 minutes left. Some people are mad.
For insurance and taxes. Right now, those are collected in the escrow. So should Mr. Satterwhite have a windfall and he can just pay it off, then he won't be paying the taxes and insurance until he gets below that threshold where that's no longer required.
Well, Judge, that issue, respectfully, I would just like an ask for a conclusion of law on that. Just the mortgage is in both their names. He's not going to be able to qualify, as I see it, to get a mortgage in his own name anytime, next 15 years. So
I would conclude that he has $1 million in his assets and his 1.75% interest in Vaco.
No. He has to pay the mortgage and $250,000.
I don't know how he can liquidate it. I don't know how he can leverage it. But he gained that interest while they were married through the efforts of both parties, and that goes in his. So this is an equitable distribution. And I'm trying to make it where hopefully Mr. Satterwhite can pay it. I'm not trying to make him get in the poorhouse. That's why I said maybe y'all can work out something to make annual payments on the disparity between the equities between the parties.
Soon.
I would have to make both of those payments annually to be able to afford this on a month-to-month basis, Your Honor. It's just, I make $20,000 a month minus $6,000 for taxes, leaves me 14. If you take 45, 22, 4,000 plus the mortgage, I'm insolvent. I can't make the monthly payments.
Yes, sir.
Judge, on the $20,000, that was a trust payment as indicated on D10. And so that was a replenishment in anticipation of this week. Certainly if there was anything left, that would be reimbursed, but given we've been here for 3 days and prepped last week, I would not anticipate that. But certainly I would follow the ethical rules of retainers.
And that was charged on the credit card, right? So whatever you didn't earn, you'll return to the credit card?
Yes, and I looked at the billing between
And that'll
preparing
go
and
to
court.
Mr.
There will not
Satterwhite's
be a
benefit.
reimbursement based upon the billing and time spent for 3 days.
Entertaining. I'm trying to think. I'm trying to think. I can't remember. Did they say he could sell the house to get, no, he has to just pay her for it.
Mr. McCormick, at the beginning, you said you would do the order. You want Ms. Kimbrell to do the order based on,
Well, Judge, since we may appeal it, frankly, I don't feel comfortable doing the order specifically since she's getting $20,000 in attorney's fees and a week and a half worth of work. So I mean,
all right,
I would
well,
just ask for her to-
we'll let Ms. Kimbrell prepare the order. Ms. Kimbrell, if you'll prepare the order and then send it to Mr. McCormick for his review. And Mr. McCormick, have 5 days to review once she sends it to you. And if you have any corrections or additions, please feel free to do so. Were there any other findings of fact that the parties believed that I needed to make for the record?
Oh, Judge, I would just think the findings of facts are necessary for the alimony and equitable distribution. So, I mean, respectfully, I don't know if sufficient, I don't believe sufficient findings were made to sustain the award across the board because I just don't see how math works for him, respectfully, but
Well,
so I would just
So
find sufficient findings on those issues accordingly.
Judge,
well, let me just say this. I adopted plaintiff 68, their marital balance spreadsheet with the alterations that I made there, which the changes that I made were that I found that the equipment for Maelstrom Studios was worth $400,000, not $200,000, based on the testimony. I found that the value for Cardboard Addict trading cards was $70,000, not $50,000, based on the testimony. And I found that the value of the Ford van was $18,000, not $16,883, based on the evidence that was presented. I also found that the value of Plantensive Solutions, the 1.75% interest that husband has in that business was worth $1 million based on the testimony, not $600,000.
I think you're missing a liability there, though. You're missing the $400,000 tax liability that goes along with that $1 million. That's not, that's got to count for something, right? That's not $1 million I'm just going to get handed. It's going to be $600,000.
And I also found a difference on the spreadsheet that was given to me by the plaintiff was that you all had put in that the house was worth $554,300. And I found that based on the testimony and evidence presented, including looking at the testimony provided by the plaintiff's expert, that the house was worth $450,000. Other than that, I adopted the plaintiff's worksheet. I did add in that the timeshares were worth $10,000 for one and $30,000 for the other based on the plaintiff's testimony.
That testimony was not correct
Judge,
either.
so the issue with the alimony, Judge, I don't, respectfully opposing counsel, I don't think they established
Absolutely,
an
yes.
amount for her need of $4,000 a month on top of consideration for getting $2,200 a month monthly payments. House
He can have $2 instead of 30.
paid for, no liabilities whatsoever. So I just don't know what there's a sustainable factual basis for $4,000 a month in alimony for 180 months. That's just, I would just like some findings for that to sustain that award as well. And the fact, he's paying the mortgage. I'm assuming is that form of alimony? Is that equitable distribution?
That's equitable distribution. The payment, the only thing that's alimony is the $4,000 a month. There's child support, which y'all agreed to the basis for all those things. There's alimony, $4,000 a month, and equitable distribution, which is the separation of the businesses, the house, the debt, and the disparity of $255,884.96.
Your Honor, if you take the taxes into account, there is no disparity. It actually swings the other way into my favor. because the taxes are a real liability, right? It's not $1 million, it's 600,000. And I think that needs to be considered in the equitable distribution, because I don't have that 255. It's not coming either.
Yes, sir. Ms. Satterwhite, I understand you disagree with me, but I've sat here for 3 days and listened to y'all talk about the value of this interest in this business. I'm not sure anybody understands it, but I heard you say it's worth $1 million. But if you had to liquidate it, it would be $600,000 because you had to pay taxes. And I didn't require you to liquidate it. So it's still valued at that amount. And you've had $30,000 almost for an expert to come in here and testify, and they can't dispute that either. They couldn't have put a price on it. So I'm sorry you disagree with my finding, but that's what I find it is. And so I'm sorry if either side disagrees with the findings. As far as the basis for the alimony, I would just find that there's a tremendous disparity in the party's income. Mr. Satterwhite makes almost $40,000 a month, and Ms. Satterwhite right now makes $700 a month. I've imputed to her making $1,300 a month, but there's a huge disparity in their incomes, and their living situation is going to be very disparate because Mr.
You make your wife make you sandwiches and you're going to have to pay. You don't do your own laundry and you're going to have to pay.
Satterwhite was given the timeshare so he can travel and take vacations and that sort of thing. The marriage is a 20-year marriage. They had a very high standard of living, at least for the last few years.
There is none.
I took into account that these are close to middle-aged folks. They're both 40 years old or thereabouts. That there are some concerns about Ms. Satterwhite's physical health, although I didn't take a whole lot of stock in her saying that she's ill now. She's not ill now. There's the potential for her being ill, but there's a potential for anybody to get ill. I looked at the financial resources of each party. Even if Ms. Satterwhite, goes and gets a job, she's not going to make near what Mr. Satterwhite makes. For her to go to school, she's been working on trying to get a degree, it sounded like, for about 5 or 6 years. And she said it would take her 2 more years to get to school. Mr. Satterwhite said he'd pay for it. I didn't make him pay for it. That's something that alimony will help pay for if Ms. Satterwhite chooses to do that. Subparagraph A6 says the contribution of each party to the marriage, including but not limited to services rendered in homemaking, childcare, education, and career building of the other party. I would make a factual finding that Ms. Satterwhite, by agreement of the parties, stayed home with the children. As the parties agreed that she followed Mr. Satterwhite before they had children, she followed him out of state to several different locations to help further his career, to the detriment of her career. And even when she stayed home, she assisted some by receiving packages for Mr. Satterwhite's business. And so for all of those reasons, I have granted alimony as I stated. Yes, Ms. Kimber.
The court asked about additional findings of fact from the defense's perspective. We do not request any, and we will prepare the order pursuant to the standing order. I would like
She only works a couple hours.
for the record to reflect Smesler versus, let me just spell it, SMELSER versus, same spellings, Smelser, 280 Georgia 92. In that case, the Georgia Supreme Court held discussed the trial court's decision in alimony and specifically clarified that there is no statutory requirement for a specific finding regarding the need for alimony or the ability to pay in the decree. So just wanted to make that on the record. Otherwise, we appreciate the court's time in the last 3 days, and I'll prepare the order.
All right, just one last thing. I've given you an order. That's the order unless the parties can agree. And I don't pretend to be a financial wizard, and Mr. Satterwhite's much more adept at figuring that out and knowing his finances than I am. If you all can talk and you decide that an annual payment versus a monthly payment is beneficial to the parties and y'all can agree, I'm fine with that. I'm not married to that monthly payment. That was just the only way that I felt like I could do an order. So
This is periodic alimony, right? Your findings periodic alimony as opposed to lump sum.
yes,
Okay. And Judge, since we have a court reporter, and I think they announced sharing and takedown, we would like half the bill sent to the wife, her responsibility to pay.
Absolutely, Judge. I've provided my contact and I'll issue a check, no problem.
all right. All right, thank you. We'll be in recess. I provided the
It's what your wife told me yesterday.
court reporter jump drives. Do y'all need to give her anything else, or is she
Yes.
covered with the jump drives?
I'll send her exhibits, Judge.
Okay, good. Thank you.
Thank you, Judge. Thank you.
Just sit tight.
Of course I'm muted. That's the perfect ending to this stream, that I'm muted. Well, they've been married 20 years. So by law, everything is split. Everything is split. He has, a lot of their assets, in businesses, and she gets half of them. I don't agree with the alimony. I just don't. She can work. She's not going to have to work at all. 10K a month. She's not going to have to work. And, with his luck during this hearing, no, I shouldn't say that. It's kind of mean. I'm just saying, Huntington's disease, let's see if she actually, we won't know, but we don't know. He might die before her. And, she might get some different disease. Or I wonder if she dies, though, does he have to pay that to the kids, or is it over? If she dies, does he get to stop paying all that? I don't know. Yeah, I'm mooching on his time right now, to be fair. I mean, it's freaking, I can still see the sun out there. So it's not my turn for quiet in the house. But I do feel like screaming at him sometimes while he's on there, so he sees how it feels. It sounds like he didn't give her a lot of crap. Sounds like she got everything she wanted, whenever she wanted it, however she wanted it. I don't know. But he's not going to be able to pay his girlfriend $2,500 a month in rent for a while. So you think she's going to dump him? Like, he became instantly less attractive to me. No, just kidding. I wonder if his girlfriend's going to stay with him. Knowing for the next 15 years, she's going to have to be the breadwinner. I bet you, though, he has more income. And he can get more bonuses. He can consult harder. No. If I did marry someone who didn't pull their own weight financially, I'm never going to do that again. No one should. I mean, it's not being mean. It's just people have to live, and it's hard to even make one person do all the work. So I can't throw anything at him because It doesn't hurt him. When I throw something at him, it never hurts him. He laughs at me. He laughs at me. If I would go slap him right now, he would laugh at me, which would make me more mad. What I need to do is turn off his internet. No, I will not. I will support half of you. The Emily half. Guys, thank you so much for coming out to this special court case that lasted a couple days long. I had fun. Sombra is absolute. Shut up. He just said a bad word. I'm going to go beat him. I don't allow that in my house. Captain America would be so, so sad. I know. I was a single mom. You don't have to tell me how much work it takes to raise kids. I mean, you don't have to tell me that. I know. But you still have to pay bills, which sucks. You just live for free when you have kids. Just kidding, Republicans. Calm down. Bye, guys. I hope you have a great night. I will see you soon. Bye. They're playing for me right now.
Got these lights that close digital dreams through the screen. Her blue eyes gleam. Wicked humor sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes near a sky so blue. In her jokes there's a truth so true. With extreme she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no